Admission item number 1. This item number 1, my lord, there is a batch of cases disposed of by the common judgment. The other writ appeal are pending that has been fixed to 4th of Monday, that means next Monday. May I give the memo so that all the can be taken up Monday? This 19 and 17 has been, 78 has been fixed to 4th, and other matters, my lord, that is not listed. Can you take up on Monday so that? Nice.
Involving similar issue have been taken on for as submitted on behalf of the other with the appeal on this is the meeting and similar other appeals. That is
Numbers are
on along with along with what is the case number? We have idea.
It's 101 of 24.
Yes.
Item number 2, may I please, your lords? Yes, my lords, the petitioner is a TGT Hindi teacher, my lords, in the Adarsh Vidyalaya of the Odisha, my lords. It's a model school of the Odisha, and challenging the amendment rule, my lords. There is in their amendment rule, they repealing the provision for the promotion of the TGT Hindi to TGT PGT Hindi, my lords.
Where is that?
There is the Annexure 6, my lords. Annexure 6 at page 99, my lords. Your lords, you can have a glance. PGT to PGT, my lords. Though all other teachers are get promotion from the TGT to PGT, but Hindi subject, so far as the Hindi is concerned, that they repealed from the previous rule, my lords. In their previous rule, my lords, that is Annexure 4, there is some provision for the promotion from TGT Hindi to PGT Hindi, my lords.
Where is that rule?
Annexure 6, my lords. That is the rule, present rule, my lords.
Annexure 6 is a notification which has been issued in exercise of power under
That is
Clause 9
yes,
of
my lords.
Article of Association.
And that is continuing on 29, my lords. Your lords, you kindly have a glance at the page 19 and the 99, my lords.
Right, there is nothing.
99, my lords. Paragraph 2, my lords. That is TG2 to PGT, my lords.
That is continued. That notification is continued.
That rule under which that notification has been issued.
That is the Annexure 6, my lords. Annexure 6, my lords. By way of amending the previous rules, my lords, that is the rules, Odisha Adarsh Vidyalaya method of recruitment and condition of
I have
service.
not been able to convey
My lord,
to you. Please see in exercise of power conferred under Clause 7 of Rule 9
my lords.
of Articles of Association of Odisha Adarsh Vidyalaya. Where is this?
You lords, you can glance para 1, my lords.
Your rule the potential.
Say
Rule
rule
the potential.
This is the rule, my lords.
Mr. This notification has been issued in exercise of some power.
Yes, society has got power, my lords.
Where is that?
You come to page 85. You come to page 85.
85, my lords. That is
First line you read. You read first line.
in exercise of power conferred by Clause 7, my lords, of rules of article of association, rules of regulation of Odisha Adarsh Vidyalaya Sansthan.
That is what my lord wants.
Yes.
Where is that?
That is the bylaws of the Odisha Adarsh Vidyalaya Sansthan, my lords.
Under the bylaw,
My lord.
some notification has been issued.
My lord.
These notifications have statutory force according to you.
My
The law.
My lord.
Very difficult. Very difficult. So we will have to see still, since you are making this submission, we will have to see what kind of this articles of association is there which has the force of law.
That articles of association have not been annexed, my lords,
Then we cannot decide.
because the previous my lords, the issue.
So it is the internal. So
Three, my lords.
No?
Opposite party number 2, my lord, 3.
Who is opposite
The
party?
state project director, Odisha Adarsh Vidyalaya, teacher, my lords.
And what is this Sangathan?
That is a society, my lords.
is it an authority under Article 12?
My lords. That is a government organization, my lords. It's a government.
Article, government organization.
My lords, it's a coming under that because it's a government organization by the school and mass education, under the school and mass education of government of.
We try to appreciate, but may be agreed by any decision of the Sangathan, which has come in form of this notification. But that does not have a statutory force. It will go before appropriate bench if according to you, the Sangathan is a state in the meaning of Article 12. The petitioner has put this challenge. When view of notification issued by Visa others, Vidyalaya Sangathan, exercise of power to confer under clause 7 of rule 9 of the Articles of Association, bracketed rules and regulations of Odisha others Vidyalaya Sangathan. The topic. Next. That is also for the petitioner has not been able to convince this court that the said notification has force of law. Challenge to it, the challenge to which can be entertained by a division bench of this court. So, what do you want?
Will come from after.
File a press writ petition.
No, my
With the matter to be placed before appropriate bench according to the roster.
Item number 3. May I please your lordship? The petitioner is indulging your lordship interference, keeping directing the authority to comply with the provision of section 3 of the Odisha Fireworks and Loudspeakers Regulation Act, your lordship, keeping in view of the ensuing annual examination to be held from 11th March to
Number 4.
3. The school and a hostel is situated within the vicinity of the temple where the fair is going to be held.
WPC number 4763.
Yes, your lords.
No, wrong brief has been given to us. The stand copy is wrong. It is income tax matter.
Record is wrongly integrated.
Yes, what do you want?
My lord, it's a form of PIL lawsuit. The authority to be directed to comply with the provision of section 3 of the Odisha Fire Gas and Loudspeakers Act, your lordship. The section 3 speaks use of pen player loudspeaker. No person shall display any explosive. Mike. Section 3, your lords.
Yes, so who is not implementing?
In implementing, the authorities are giving permissions without complying this rule 3, section 3, because the exam is going to be held from 11th March, your lordship. There's a hotel and the school, there's a residential school also, and Sebastian also.
Who has to enforce?
The sub-collector of Arbitrator, opposite partner 5. If a direction will be given to opposite partner 3,
Where is this act? Odisha Fireworks Loudspeakers Act. Where is that?
180. 180. 180. 180. Section 3.
I'll go and check. I'll go and look. Our authority, watching that implementation do करिए.
This ground is next to school,
Yes, your lordship.
but now schools must not be there.
My lord,
Classes are going on. Classes are not going on now.
the exam hostels is there.
Ah.
Hostel is also there.
Still is.
Yes, your lord.
Do you have the Supreme Court's decision on this? Do you have the Supreme Court's decision on this?
Sorry, my lord, I don't have
Please
that.
find out. The public interest litigation, you will have to work more than you usually do.
You must have got some certification or grant of license to hold the fair.
No,
from the local authorities.
they have to, they have to,
Police,
they have to apply. The,
police
apply,
department must have given them permission to hold the fair.
They have to take permission. Till that, my instruction is not having given, so permission has not given the mark. It is coming on eight into Shivratri.
You want a preemptory order? Anticipatory. You want an anticipatory order?
My lord, anticipatory, the exam is going to start from 11th of March to 16th. At least that period, because the theatre, everything, and the hostels are, so it is going to be to disturb the students who are so my lord, so therefore,
So what do you want us to do?
my lord, for that period, so at least the office will give permission to conduct the trial in such a huge and crowded manner.
Please come to rule 3, sub rule B of rule 3.
Well, as per the section, the authority should not have given permission within the vicinity because it is coming under the it's because
They
the
filed an appeal. Anyone could have preferred an appeal. Whether any permission has been granted.
my lord, if your lordship may kindly liberty, then I will go and file an appeal because it is not been granted as per my instruction that permission has not been granted because the fair is going to be held from on 8th onwards.
Which fair?
It is Shivratri fair. It is on the occasion of the Shivratri only. So exam is starting from 11th and it is going to be end at 15th. And the fair is going to be conducted for more than 1 month. I am not saying that for the whole period because at least after the exam is over, then the students will go out to hotels and everything. There is no problem. So at least for this period also, if the authority is given.
If any permission has been granted, then you can approach. If no permission has been granted,
My lord, if that negotiation or if the permission has been granted, I will even take the bits.
present writ application in the nature of public interest litigation has been filed. Taking direction to, you must implement the order, Mr. Who is for the state.
Yes, my lord, yes.
If we have any concrete example, any specific example that the provisions have been violated, then we shall direct for initiation of action against the person responsible for implementing the provisions of the
The
act and the
authorities must
regulation.
ensure that all these provisions have to be strictly complied.
Yes. Seeking direction to competent authority not to allow which fair?
Shivratri.
Shivratri fair. Scheduled on
8th March.
8th of
8th
March.
of March on the ground that that may violate the provisions of Odisha Fireworks and Loudspeakers Bracketed Regulation Act 1958 and Odisha Fireworks and Loudspeakers Bracketed Regulation Rules 1965. Stop. Learned counsel appearing on behalf of the petitioner has submitted that board examinations are going to commence since 11th of March.
Yeah.
And if the provisions as contained in the Act and the rules are violated, the career of the students appearing in the school shall be adversely affected, as they may get disturbed in preparation for their examination. Learned counsel, after some argument, has appreciated that there is provision of appeal under rule T bracketed B of the rules in case permission is granted in violation of the provisions of the Act and the rules. So stop. In such view of the matter, he seeks permission to withdraw the writ application with a liberty to approach prescribed authority under section 3, under rule 3 bracketed B of the rules, if situation so warrants.
This is annual examination.
Like the annual, it's not board exam, annual examination.
It is not board exam.
No, it's an annual examination.
Annual
Annual
examination.
examination. Annual examination.
Deeply obliged papers.
Board examination.
Item number 4, may I please your lordship, my lord. This is the second.
The direction for your disposal of the representation by the opposite party is contempt of law. Granting for each time, I will see that the order is complied on.
Last chance.
This
By-
second contempt.
Yes,
This is
Second,
contempt.
one second, we will not give you any time.
no, I will obtain instruction whether it has been.
No, sorry. Sorry.
In September, we have given three.
And
months.
this, sorry,
My lord, Annex 1, page 7, my lord. The order dated 16/2/2023, my lord.
So, probably next Thursday, so that I can obtain.
no, let him come. We will initiate contempt proceeding.
If he has disposed of the representation, because there was a direction for disposal.
Then you tell us that one. You tell us that the representation has been disposed of. If you don't, then he will have to appear to, we will be framing charge against. Yes, if you wish, you can.
Like we are Monday.
No Monday. No Monday. We cannot be so liberal in contempt matters. This is second contempt. Where is that order?
My page, Annex 1, page 7, my lord. Relevant page is 9, my lord, relevant page. Para 5, my lord. As agreed by the Lord Council for the parties and after going through the records, this court, without expressing any opinion on the merits of the case, disposes of the writ petition, directing the Office Department of Court to consider the representation filed by the petitioner by the Annex 16 and pass appropriate order in accordance with the law within a period of 3 months from the date of the production of the certified copy of this order, madam. When the Tosler did not take any step, I filed the first contempt, kind of glance Annex 3, page 12, my lord. Page, running page, relevant page 13, my lord.
para 4 ma'am, let the opposite party comply with the same. If not already complied within the meantime, within a period of 3 months from the date of the communication and the production of the certified copy of this order by the petition matter.
Who is opposite party? Who is the contender?
Tahsildar Odoga, my lord.
Tahsildar?
Odoga. In district of Nayagad, Odoga.
The petitioner had earlier approached this court by filing a writ petition under Article 226 of the Constitution of India, giving rise to WPC number 2752 of 2023, seeking following relief. Following relief. The writ petition was disposed of by a division bench of this court on 16/2/2023, granting the directing the opposite party number 4 in the said case, bracketed Tahsildar
Odoga. Odoga.
Odoga.
Odoga, bracket closed, to dispose of, to consider a representation filed by the petitioner at annexure 16 of the said writ application. First off, since the opposite party number 4 did not comply with the order, the petitioner had no other option but to approach this court by filing a contempt application registered as contempt CONTC number 5825 of 2023. First off, the said application was taken up on 26/9/2023 by a division bench. First off, the division bench noted in its order dated order passed on 26/9/2023 that this court's order dated 16/2/2023 had not been complied with by them. First off, the court, however, taking a lenient view, disposed of the contempt application with an observation that the opposite party must comply with the order within 3 months from the date of communication / production of certified authenticated copy of the order by the petitioner. Stop. Next, this second contempt application has been filed by the petitioner, alleging that till date his representation has not been disposed of. Stop. Next, we are of the prima facie view that the defiance of the court's order by the concerned opposite party, bracketed ES, is willful and deliberate. Such defiance needs to be dealt with sternly by the court exercising contempt jurisdiction. Next, who is he? What is his name?
Dikhe Sahu.
PK Sahu.
Dikhe Sahu.
He is the Tahsildar.
No, Tahsildar Manas Ranjan Bhoi. Tahsildar name is Manas Ranjan Bhoi.
Tahsildar of so and so, Anand Ranjan Bhoi,
Manas Ranjan.
Manas Ranjan Bhoi be personally present in court on next Friday for this court to frame charge of commission of contempt of charge of contempt of court against him. To stop. He will be required to show cause on the said date as to why contempt proceeding be not initiated and he be not punished for deliberate violation of this court's order. First off, he shall also be required to inform this court as to who were the officers. Inform this court names of such officers who were holding the post of Tahsildar of which place?
Odogaon.
Odogaon, since the date when the first order was passed on 16/2/2023 till date. So all of them, not only one. No, sorry. Sorry. Mister, if on that date, the court is satisfied, even if the order is complied with in the meanwhile, if the court is satisfied that the order was deliberately violated, we will send him to jail from here. Yes. So he should come prepared with his clothing and yes. All right, next Friday, the bar for Friday. Don't dare do it.
No.
Don't dare.
In fact, pursuant to Lordship, 100 days observation, now the Chief Secretary has issued a notification to all the officers.
Yes, we may take up all the contempt matters on one day.
Yes.
For disposal of all the cases.
So I can produce before
Yes.
the letter of the Chief Secretary. He has
All right.
instructed all the
Letter of the Chief Secretary will save the Chief Secretary only.
No.
All right. He has letters to the officials for implementation of the order.
No.
That will save him. That at least he has taken steps to implement this court's order.
Right.
But those who are violating, they will be dealt with sternly.
Right. No, message are already.
They will be, yes.
Item number 5.
5 and 6. Similar matter.
Inadvertent, not willful, subsequent conduct. These are the circumstances when we can ignore.
Right.
But otherwise,
5 and 6. Similar matters to dispose of batch of such plots. The 28 capital A application.
just a minute, just.
Item
कौन सा?
5.
5 and 6. 5 and 6.
Yes, sir.
Granted me for 6 weeks time to comply the order. This first content. 28 capital A.
First contempt, all right. First contempt, 6 weeks to comply, 5 and 6.
Item 7.
Second contempt, punishment guaranteed.
Right.
Yes.
7, my lord, permitted to withdraw. Item
Withdraw.
7 permitted to withdraw. Item number 8.
Lordship, this case has become infructuous, Lordship,
Infractions.
obliged, Lordship.
Item 9.
No one appears dismissed. 2001 matter.
Item number 10. Item 10, well, this has become infructuous.
Infractions.
Item 11.
My lord, pass over.
Sir,
The council the another court. This is another court.
Absolutely.
Oh, sir, pass over.
As requested on, when do you want? कब चाहते हैं? When do you want?
Sir, another court sees another court. Care Sir, second hour.
Next week.
Item 12. May I please, your lordship? Item 12, your lordship. 12 and 13, your lordship. Two cases. First one is, your lordship, workman has challenged the award passed by the presiding officer industrial tribunal in respect of where reinstatement has been allowed in favor of it, but that was just denied. That workman has filed, and the management has filed challenging the entire award. That is my reinstatement. Reinstatement.
I just pray one. The first time it has come out. Next Friday, if your lordship take up, it is with the corporation. I'll just obtain instruction and I'll dispose of it.
All right, as requested on behalf of the petitioner in WPC 14423 of 2014. List this matter on 1 week.
Item 13. Sir.
My lord, item 13, my lords, I am there for the corporation opposite party employer, my lords. This is an award challenged by the petitioner, my lords, granting 30,000 compensation, my lords. And rightly, the London Labour Court has passed the award because, my lord, his wage was 15 rupees. And he was a daily wager and not appointed as per rule. All those things are there. So, but other side is not there. Perhaps I leave it to your lordships, my lords.
There is no representation on behalf of the petitioner. Then counsel for the opposite party is present. So, since the matter has remained pending since 2015, Oma lists this matter on 2 weeks, expecting a representation, petitioner's representation on the said date.
May I pray, my lords, before 22nd March, because 22nd March to 1st April, I will be absent, my lords. 15, 16, yes, my lord, deeply obliged, deeply obliged, deeply obliged.
Item 14.
May I please? My lord, 30 on that day. On 27/2, my. The petitioner is, my lord, only one thing before I start. The petitioner is a graduate, arts graduate. He has Rashtrabhasha Ratna and his BA. These three things, my lord. He is a graduate. Rashtrabhasha Ratna.
Yes.
And his BA.
BA.
My lord. Now, my lord, kindly turn to page 56, please.
So there is no dispute about this.
Yes,
There is no dispute about this fact that you are a B.Ed, graduate, and Rashtrabhasha Ratna.
Yes, and B.Ed also. Oh, yes, B.Ed.
Yes.
Only dispute is I have got it from Jammu University.
No
Who is that dispute?
No, that. Now, my lord, kindly turn to page 56.
66.
56, 56. My lord, Sabbath.
Yes.
My lord, Sabbath.
Yes.
My lord. My first submission, subject to my lord's acceptance, This is the educational qualification essential. My lord may kindly see. My first submission, if my lords accept, then I proceed further. This qualification prescribes two types of qualification. Because my lord will find on the left hand side or, then in the middle or. So it prescribes two types of qualification. One type, first category and second category. This is my first submission, my lord. Then my next submission, my lord, may I read? Hindi teacher. Here is a case of Hindi teacher. We are concerned with Hindi teacher. Bachelor's degree he has from a recognized university with Hindi as one of the, he doesn't have. My lord, may skip. Then or with. Again, you will go back to that first with Rashtrabhasha Ratna he has. So, my lord, the next or is not required. Next or again is not required. Next or is again not required. So, what is required, my lord? That and. So, he has bachelor's degree, he has Rashtrabhasha Ratna. Now, and Hindi Shiksha Parangat from Kendriya Hindi Sansthan Agra / BHED, a course prescribed by NCT bracket ends from an institution recognized by the NCT and affiliated to a recognized university / BEd in Hindi, a course prescribed by NCT from Dakshin Bharat Hindi Prachar Sabha Madras, a institution recognized by the NCT and affiliated to a recognized university. So, my lord, my second submission will be that BEd,
This and this, whether this and has to be read with fourth or.
yes, ma'am. Yes,
This and has to be read with fourth or. This and is not to be read with all other ors.
my lord, that is, then, my lord, my submission is,
No, this is what, yes, brother?
my submission is, no, my lord, all the four hours, you can have Hindi with any of the four hours, then and. This is our understanding.
This and.
Yes.
According to you, after this or this is and. So this and is to be read with
This-
one. This and is to be read with one.
Yes,
V1.
my lord.
This and to be read with second or first or. This and to be read with
Second or.
second or. All right. Now read one with and.
Yes, ma'am.
Hindi teacher, bachelor's degree from recognized university with Hindi.
With, my lord, that is important. With Hindi as one of the elective subjects.
Yes, with Hindi. Forget that.
My lord.
Forget other ors.
My lord.
Forget other ors. We will be reading one with and.
My lord.
That can be done.
Yes, my lord.
So whether that creates an incongruous situation, then your submission cannot be accepted.
Yes, my lord. Accepted, my lord.
Please see.
Then I am reading again, my lord.
Bachelor's degree from a recognized university with
University with
Hindi as one
Hindi-
of the
with
elective
Hindi.
subject.
And Hindi Sikha. This is my lord, plain graduation. This is BA.
You, at one stroke you read whatever is relevant, at one stroke you read,
Yes, ma'am.
so that you can understand.
My lord. Hindi teacher, bachelor degree from a recognized university with Hindi as one of the elective subject with minimum 50% marks in aggregate and Hindi Shiksha Parangat from Kendriya Hindi Sansthan Agra / BHED, a course prescribed by the NCT from an institution recognized by NCT and affiliated to a recognized university / BEd in Hindi, a course prescribed by NCT from Dakshin Bharat Hindi Prachar Sabha Madras, an institution recognized by NCT and affiliated to recognized university. So, my lord, our requirement was you must be a graduate with Hindi or Shastra or Sasri or Snatak or an equivalent degree. It's not required because the petitioner has Hindi, a bachelor degree with Rashtrabhasha Ratna. And when it comes to the training part, he doesn't have BEd in Hindi, my lord.
All right. So this is your submission that this and
Yes.
This and is basic essential qualification. So you have not appointed any person who does not have this qualification.
Yes, my lord. Who doesn't have this qualification? Yes.
All right.
Yes.
This is your submission.
Yes, my lord. And now, my lord, then my lord may kindly see, my lord has seen the resolution now. Now, my lord may kindly come to the prayer. With what prayer the writ petitioner approves this honorable? My lord may kindly see that. The writ petition, my lord, I have annexed that writ petition. My lord may kindly turn to page 18. My lord will find the prayer of the writ petition at page 28. My lord, sir, page 28.
Of the writ petition.
My lord, of the writ appeal, my lord. I have annexed that.
Appeal.
My lord, I have annexed that writ petition to the writ appeal at page 28 of the writ appeal, my lord, may kindly see.
Yes.
My lord, have it? My lord, it starts from page 28. Relevant is page 29. The next page. Issue appropriate married man.
Page 29.
Page 29. The next page.
Yes.
My lord, issue appropriate writs orders to quash rejection of the petitioner's candidature to the post of contractual Hindi teacher as per Annexure 10. Then 1A, issue appropriate writs orders directions quashing the condition of having BA in Hindi Parangat from 3 particular institutions. That is under, then he has quoted. So important is, she sought to quash the condition of having B.Ed from 3 particular institutions. Then, my lord, may kindly come to prayer number 1A2. Issue appropriate writ order directions to declare the B.Ed from Jammu University with Hindi as one of the subject and medium and examination of Hindi as the requisite qualification for Hindi teacher as required by the said government. So with these 3 prayers, with this advertisement, my lord, with this condition, educational qualification, the petitioner has approved this honorable court. Now, my lord, may kindly permit me to take to the impugned judgment. May I take, my lord, to page 57.
Yes.
My lord, before I take, my lord, to page take through the judgment, one more factual aspect I must also bring it to my lord's notice. He has got B.Ed from Jammu University. There is again a problem there.
What
It
is
is
Jammu?
not B.Ed
Where is
in
Jammu? Where is Jammu?
Jammu Kashmir University.
Jammu.
My lord. The problem again in that certificate is, it is not B.Ed in Hindi. I have shown, my lord, B.Ed in Hindi. That were shown to this honorable court that it was a Hindi as a medium. That B.Ed certificate, I'll take, my lord, to that B.Ed certificate. But before this is the factual aspect, my lord. Now, let me take, my lord, to page 57. My lord has, my lord, sir, page 57.
Yes.
On perusal of the above mentioned educational qualification prescribed in the resolution, which has been considered as advertisement for recruitment to the post of Hindi teacher, it is evident that a candidate must have different qualifications as prescribed therein, along with training qualification acquired from 2 institutions, namely, it will be 3 now. 2 institutions, namely Hindi Shiksha Parangat from Kendriya Hindi Sansthan Agra, BHBEd, a course prescribed by NCT from an institution recognized by NCT and affiliated to a recognized university, and 2, B.Ed in Hindi, a course prescribed by NCT from Dakshina Bharati Hindi Prachar Sabha, Madras. Then, my lord, admittedly, the petitioner has acquired B.Ed training qualification in Hindi from Jammu and in Hindi My lord may kindly mark it. From Jammu University as per the certificate produced by him enclosed as annexure to the petition. But as the training qualification acquired from Jammu University has not been included in the advertisement itself, his application has been rejected by annexure 10, though it only reflects not having requisite qualification. In the remarks column, what requisite qualification the petitioner doesn't possess has not been indicated therein. It is admitted that the petitioner has acquired bachelor degree in arts from recognized university with Rashtrabhasha Prachar Samiti Wardha. That means he has got initial requisite qualification as per the advertisement, but he does not possess training qualification as has been prescribed in the advertisement, which was subsequently clarified in the counter affidavit filed by the opposite parties. The very use of the word "and" in the advertisement has disjoined the initial qualification acquired by the petitioner, which is in accordance with the advertisement. Therefore, one may have got initial qualification, but he is bound to acquire the training qualification from the two institutions as prescribed in the advertisement itself. It is therefore clear that by using the word "and," the essential qualification has been disjoined from the training qualification. Then my lord may kindly turn to page 63. I am taking my lords through to the relevant portions only. I am not reading the entire judgment, my lord. My lords have page 63.
Page
63, my lord. 63.
yes,
Now, para 18. In view of the settled position of law as indicated above, this court is not competent to interfere with the qualification prescribed by the authority when the same has already been acted upon. Thereby, the relief sought in clause 1A cannot be granted to the petitioner.
yes,
My lord. Then I will take my lords to page 66, please.
yes,
Para 23, my lord. As the list of rejected candidates, Hindi teacher in Annex 10 does not indicate the reasons. The same cannot be supplemented or supplanted by way of affidavit filed on behalf of the opposite parties, clarifying the position that the petitioner had no training qualification for which his candidature has been rejected. The Constitution bench, my lord, thereafter, my lords have held that why you have not assigned the reasons, and we cannot improve on that in by way of an affidavit. Then my lord may kindly, because that was relevant, I had shown. Then my lord may kindly turn to page 72. My lord, page 72.
yes.
My lord, I am placing para 28. As per the advertisement,
No, but this finding,
my lord,
paragraph 27, last line.
at Jammu University from which the petitioner acquired the training qualification is duly recognized by NCT and affiliated to Utkal University. Therefore, he approached the Odisha Administrative Tribunal. That was, my lords, because he said that no, it is also recognized by the university, even though it is not mentioned in the advertisement.
No, but this is finding recorded by the learned single judge.
My lord. Well, let me read para 27.
Is there any dispute about it?
Yes, my lord. So, the prayer, my lord has seen the prayer. Let me read para 27 for better appreciation of my lords. In the above judgment, their lordships, my lord, I am reading at page 71, para 27. In the above judgment, their lordships have differentiated the principle insofar as the candidate, by agreeing to participate in the selection process, only accept the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The prescribed qualification is the prescribed procedure which the petitioner accepted. There is no doubt about it. As Jammu University, from which the petitioner acquired the training qualification, is duly recognized by NCT and affiliated to Utkal University, therefore, he approached the Odisha Administrative Tribunal.
So Jammu University is affiliated to Utkal University.
Yes, madam. But this is, madam, we'll see.
Jammu is where? Jammu University is located where?
Equivalent. Equivalency. The equivalency. Because our university, madam knows, the university declares equivalency. If BA from
Equivalence is different thing. Affiliation is different thing.
that is wrong word.
Wrong
That is
word.
actually to be read as equivalent. Madam. Then, so madam, here he has approached, my lords have taken note that he has approached the tribunal under this background. My lord, I have already read the prayer which was made. So, my lord, now see para 28. As per the advertisement, the untrained candidate shall have to undergo required training within the timeline as prescribed by the government. This clearly indicates that the candidate having no training qualification can also be considered for selection as Hindi teacher as per qualification prescribed under clause 3F of the advertisement. Since the petitioner has got the basic qualification and training qualification, along with B.Ed from Jammu University, his application should not have been rejected on the ground of want of requisite qualification. My lord, most humbly I will submit this is contrary to his prayer, man. My most humble submission, man. More so, the university from which the petitioner acquired the training qualification is duly recognized by NCT and affiliated by, this actually, it will be, my lord should read it equivalent. Affiliated, equivalent by the Utkal University, as is evident from the materials available on the floor. Therefore, rejection of his application mentioning not having requisite qualification cannot sustain the eye of law. As such, the petitioner has received information on the Right to Information Act 2005 on 21/12/2016 from the choice list, namely Honorable District 19418. There are 24 number of posts of teachers, and out of which 2 belongs to ACBC category, and on the basis of RTI information dated 24/18, so far as Jajpur district is concerned, total 42 numbers of posts of contract teacher, Hindi teacher are lying vacant. Contract teacher, Hindi are lying vacant, out of which 2 belong to ACBC category, and on 4/6/18, the Director of Secondary Education also provided information indicating that out of total 799 contract teachers in Hindi, 388 posts are still lying vacant. Therefore, if the petitioner's application is considered for selection and engagement as contractual teacher in Hindi, it will not cause prejudice to anyone. In view of the aforesaid facts and circumstances, this court is of the considered view that the relief sought by the petitioner so far as prayer number C1A is concerned, the same cannot be acceded to. But so far as relief sought in prayer number CI is concerned, as the vacancies are available, the petitioner's application should be considered for engagement as contract teacher in Hindi as per the choice exercised by him as expeditiously as possible. My lord, because of vacancy, my lord, the Honorable Court having found that he has not come under the qualification that cannot be granted, then the Honorable Court granting that we should, because there are vacancy will go to the next year, my lord. It is
That and qualification he does not have.
he doesn't have, my lord. As per the advertisement, my lord.
No,
That is
as
my
per the
case.
advertisement, yeah.
That is my case, before this Honorable Court. And my lord,
And therefore he was selling that part of the advertisement.
yes, ma'am. And one last thing, my lord, I will conclude before, if at all I will be required to answer any further. His B.Ed so-called that Jammu University, my lord, that my friend will definitely show to my lords. That is not B.Ed in Hindi. I have also checked it. I was checking that.
You say it is not BHED, but it is B.Ed in Hindi language.
Yes, it is not B.Ed.
The qualification is to be BHED. The qualification as prescribed in the advertisement is BHED, not B.Ed.
B.Ed in Hindi and slash BHED.
B.Ed in Hindi.
I read that. Shall I show it to my lords again?
So he has B.Ed
B.Ed.
in Hindi instructions.
In Hindi medium.
Medium. So
it is not B.Ed in Hindi. Well, my respectful submission to this honorable court will be B.Ed in Hindi medium and B.Ed in Hindi are two different things.
Like B.Ed in physics, B.Ed in chemistry, B.Ed in any other subject.
There is no such.
But,
Throughout the state, there is no such subject. B.Ed in physics, history, English, Hindi, not like that.
that
It
is
is
not.
always been Hindi medium because he has to be employed as a teacher to teach Hindi as a subject in matriculation high school stage. Nowhere in the curriculum, anywhere, my lord, may kindly.
either
require.
at school level, they should have, or college level, they should have elective subject. Elective subject as Hindi.
Yes.
One of the subjects, elective subject.
That is why that Rashtra
Can we see the difference between, so far as B.Ed qualification is concerned, for the post of B.A, for the post of Hindi and any other subject like English?
No, there is no such. To my personal knowledge, and I have verified also.
No, there is no course of personal knowledge.
In any curriculum also, I didn't find one, Leonard, there is a B.Ed in English, B.Ed in physics, like that, nothing like that.
No, there may not be there.
That is not there. So therefore, unlike that, B.Ed in Hindi, it means in the medium or as a subject. One of the subjects. B.Ed means, my lord, it is a skill to teach the student. That B.Ed is a training.
You have taken instructions, you have taken
How to teach
instructions
the
in Hindi.
student, the manner, methodology, pedagogy, all these things, my lord.
That is a secondary argument. But my first argument that he doesn't have qualification as per the advertisement.
Yes.
No, but where is the equivalent to this and given in the advertisement? Where is that equivalent clause? Equivalence clause mentioned in this and?
No, there is no such equivalent clause, my lord. That's
Yes.
why he prayed.
Yes, there is a clause, my lord. I will show the entire resolution that has not been quoted. I will show, my lord. Let him complete, I will show.
I have completed. That's all my argument.
All right.
Therefore, what it is, my lord.
So this is an admitted position that
Yes.
this and is an essential qualification.
My lord.
You have to demonstrate that you
That is
possess this qualification.
My lord.
So come to and.
Yes, I have read it, my lord. I have also read it. I have given, may I
draw my lord sentence, that is the quoted person only is that in the judgment, impugned judgment, it has been quoted, a part of that resolution. That resolution was on record also. I have given a compilation of documents before my lord. Kindly see that compilation. I have given the entire
That
resolution.
was on record
Yes, yes.
in the writ proceeding.
Yes, read procedure there, but I have made it a smaller one. I have given the compilation. That is there on record before the writ appeal court. That is compilation of documents filed in the writ petition. I have given it. That is on 29/9/22. There I have given the entire resolution.
When did you, where is that?
My lord, 29/9/22 I have filed it.
Compilation.
My lord, there is a resolution at page internal page 3.
A by
That-
4, A by 4.
My lord. That is the entire resolution which has been quoted. My lord, kindly turn to the clause 1, eligibility. The first one. The relevant is, my lord, next page 4. D, small d.
Is compilation of documents, which page?
My lord, this is Annex A by 4 there,
Fifth,
page 3.
fifth page.
Page 5,
3. Say compilation.
of that,
Compilation. Compilation, the page 3.
that is resolution.
Yes.
Huh.
Yes, the
You are
next page.
taking us to page
First
5.
page, next page.
Next
4. Next page. 1D.
Educational qualification.
1D. Essential qualification, that is there, my lord, eligibility. So just a relevant person, because the last question, my lord, the Chief Justice has put it. Kindly see, my lord, D, small d. Such outside university stroke institution candidates shall have to produce the authenticated proof of equivalency and NCTE, National Council of Teacher Education, recognition in support of their qualification at the time of verification, failing which they will not be eligible in the selection process.
So equivalence
Yes.
can be applied only if the advertisement talks of equivalence.
My lord, this is the advertisement. This is the part, this is that part with the, this is the resolution at page 56 of the impugned judgment. What it is quoted is only this part, clause 3. Towards bottom, my lord, the educational qualification.
Therefore, it is mentioned that when a question of equivalence arises,
My lord,
how that will have to be resolved.
my lord.
All right.
Yes,
So from the advertisement, we may have to see equivalence is for above end.
yes,
Above end, there is the expression equivalence used. But in the end, equivalence is not used.
I'll show it.
It is not there in the.
Yes, my lord. My lord, kindly see page 6, page 6.
Yes.
My lord, what it is quoted, the requirement is essential educational qualification at clause 3, page 4. I have read small d, but towards bottom 3D.
Under the eligibility para 1, under the eligibility para 1, you are referring to clause D.
Now, my lord, kindly take this, take note of this D. Thereafter, my lord, kindly, what is the educational qualification? If I have the educational qualification, so I am to go to the equivalence. So I have read it that yes, equivalency clause is there. So now kindly come to 3, the educational qualification. What he has read, that I am reading it once again.
Where?
This page 4, my lord, where I am. Page 4, that compilation, that resolution.
Page
What
4 I am
for that?
there.
I have read 1D.
Page 4 I am there, page 4.
No.
Page 4 I am there.
1D.
Compilation of documents filed by the writ petition.
No. That resolution department.
Compilation. Yes,
My lord, got it.
yes,
The same thing, madam. That is,
yes.
I have placed the small d now towards bottom educational qualification. What it has been quoted there. My lord, kindly turn to 3F, next page, page 5, Hindi teacher. We are concerned, my friend has read out through this. 3F, page 5. Bachelor degree from a recognized university with Hindi. This is the original resolution I am reading. Bachelor degree from recognized university with Hindi as one of the elective subject with minimum 50% mark in aggregate, 45% for SC, ST, PH, OBC, SCBC candidates, or with Rashtrabhasha Ratna from Rashtrabhasha Prachar Samiti Wardha, or with Shastri from Odisha Rashtrabhasha Parishad Puri, or with Snatak acquired by June 2005, the date up to which the temporary recognition has been granted from Hindi Shiksha Samiti Odisha Cuttack, or an equivalent degree from a recognized institution with at least 50% mark in aggregate, 45% for SC, ST, PS, OBC, PH, SCBC candidate, and Hindi Shiksha Parangat from Kendriya Hindi Sansthan, Agra, stroke BEd, BHEd, a course prescribed by the NCT from an institution recognized by the NCT and affiliated to a recognized university, stroke BEd in Hindi, a course prescribed by NCT from Dakshina Bharat Prachar Samiti, Hindi Prachar Samiti Madras, a institution recognized by NCT and affiliated to a recognized university, or bachelor degree with Hindi as one of the optional honor subject with minimum 50% mark in aggregate, 45% SC, ST, PH, OBC, SCBC candidate, MA in Hindi with minimum 50% mark in aggregate from a recognized university. Now, my lord, this bracketed person. The entrant candidates shall have to undergo required training within the timeline as prescribed by the government. There is also a provision. If somebody didn't have a training qualification, he can also be he is also otherwise eligible to be selected, and the government will prescribe a time limit to undergo this training qualification if a candidate do not have. So my argument is, now taking all this into account, my lord, my first submission is, I got the BEd in Hindi.
Did you find the difference that the expression equivalent
My
is there for other qualifications, but it is not there for this qualification after the and begins.
yes,
After and there is no equivalent mentioned. That is intentional.
yes, that is why my submission is this equivalency clause, since it is not there in general, that in 1D.
1D will apply to the qualification above and, because equivalent is there. So for clarifying that, D may be used.
My argument is twofold, my lord.
First argument can be onefold. And that is that even if you did not have
The training.
the BEd qualification, your candidature ought to have been considered because of this untrained candidate clause.
Stabilize, my lord.
That is the
This is
only,
one. The other
only
one,
thing which you may. I don't
yes, that is why I've said twofold for the reason. My respect submission. If this is the first argument I will advance before my lord, yes, my lord have considered that aspect first.
Here there are two types of educational qualifications also prescribed. You see, BHEd,
My
a
lord.
course prescribed by NCT. That is one,
Yes,
right?
yes,
Another qualification is also prescribed, BEd in Hindi,
yes.
course prescribed by NCT.
In seat. That I am there, madam.
So there are two types
So
of
whether
qualifications.
this course has been recognized by NCT.
Yes, that is my submission, man. That is why I say I have twofold argument. The first one, my lord, I will taken, so I am not to argue on that one. The second is this part where my friend is disputing. The second part is, as my lord Justice Raman has said, BEd in Hindi, a course
Dakshini Bharat,
is recognized.
Yes.
So this is available. And now only I am to satisfy my lord whether there is a NCT affiliation to this recognition to this particular B.Ed certificate I have obtained from Jammu, and whether our state universities has accepted that or not. These two things I will satisfy to my lord.
Then also another thing,
My lord.
from Dakshin Bharat Hindi.
No, that is
also,
that is the prescription.
that is including there.
Dakshin Bharat Prachar Samiti is
So they are
also,
restricted to that.
no, they say, but yes, they are restricted only to that Dakshin Bharat. That is why I am before my lord. This is that why I am submitting. I got a B.Ed, maybe not from Dakshin Bharat. My respect submission, the authorities have discriminated. I got a B.Ed certificate from a affiliated university or the recognized university under NCTE, which is the apex body of the government of India. And that qualification was also recognized or given the acceptance by our own university or state university, that is called Utkal University. That two document I will show my, thereafter I will proceed further. So kindly turn to that clause, that document itself. I will come to page 11 first. Because that the document, that rejection order, my claim was rejected, page 11, the ground. They have not stated I am untrained. They have not stated I am not having the Hindi. They just said one word, the rejection order, not having requisite qualification, page 11 man. That is the issue order before the honorable court. So they say not having requisite qualification. Neither they are saying you are not at the B.Ed, as my friend is now developing his case, nor they are saying you have BA qualification.
So that reasoned order is not required to be made in selection process.
Yes. So
when they say that
the issue.
they are not,
So now kindly,
not qualified.
yes. Now kindly,
That order is not required to be passed in the matters of recruitment or
Fine.
selection.
So they say you don't do the qualification. Now kindly turn to page 12, my certificate. I have obtained this B.Ed certificate and mark sheet I have given, that is from Jammu University. There is no dispute over that. Now next page, page 13. That is NCT communication. To all education secretaries or get page 13. Issue related subject is issue, it is letter of the NCT to all education secretaries of all state government or union territory as per list. Issue related to validity of degree in teacher education obtained from state of J&K. Sir, NCT Act 1993 extended to whole of India except the state of J&K. The issue of validity of degree in teacher education obtained from state of Jammu Kashmir has been attracted the attention of the NCTE and MHRD for quite some time past. Now the MHRD has given the following clarification. Persons who have obtained degree from institution recognized by the government of J&K stroke UGC would be eligible for employment in central government and state government. So this was the
Against
clarification.
you.
Pardon, ma'am?
This is against you. This communication is against you for the reason that the advertisement specifically prescribes that it must be recognized by the NCTE.
Well,
Your this qualification is not recognized by NCTE because NCTE says that Jammu does not
jurisdiction.
does not come within the jurisdiction.
but what they say,
However,
they say
the qualifications can
acceptable
be acceptable.
for
That
appointment.
this is for a different reason.
No, but this is, I am seeking an employment only. I am not taking more, madam.
All right.
Well, this is for employment. Now, basing on this, now kindly see the Utkal University has issued a letter. Next page, page 14. This is Utkal University clarification. Please find herewith a approved list of universities which B.Ed, special education, MEd, regular and correspondence courses have been made equivalent with the correspondent to B.Ed, special education.
The question is that according to this communication, the qualification obtained from Jammu can be an eligibility criteria, but
Right.
it cannot force the state governments to have this eligibility condition. The NCT cannot tell the state of Odisha that see now since we have recognized they may be eligible, but the employer can decide that we shall not be taking candidates from particular institution or whatever.
With due respect, my lord, after that introduction of the RT Act, Right to Free and Compulsory Education Act, Central Act, that 2009, the state government is bound by the, because RT says whatever the educational qualification for these high schools and schools, elementary schools, the qualification will be fixed by the apex body, that is the NCTE. And after that, my lord, now state is bound to accept whatever the qualification or the procedure with regard to qualification by the NCTE.
All right.
My lord. So now, my lord, basing on these two documents,
Yeah.
I have applied, along with many other persons also, they have come to this honorable court.
This is which page? Annexure 15?
15, my lord. 15 is serial number 19.
Which page of the writ petition?
Writ petition. I have to go very
It was there in the writ petition.
Yes, it is in the writ petition. I have reconciled and filed it here. That was annexure 16. I have caught it, my lord, kindly see right hand column. Probably that is the, just I have to read. Because I have caught it and filed it once again for reference only. Because these are the three issues only to be decided. It's a bulky document, therefore I have given it in one place.
Yes.
My lord. Shall we continue after, my lord?
Yes. Yes, they are coming. Yes.
My lord. So these university at page 14 has declared it equivalent, and the name of Jammu University is page 15 at serial number 19. So now, my lords, besides all these disputes now we are raising, my lord, as my friend is raising, this identical issue was also before this honorable court in a writ petition. I have that document, I have filed that order, I have filed division bench order, because in that case only the case was dismissed. My case was transferred from tribunal to this court and this was allowed by the honorable single judge. But the other person, he has filed a OA in the tribunal and it was dismissed. Against that, he came to this honorable court in a division bench. And that writ petition order I have given, my lord, the net copy I have given, page 17. This identical issue, an identical person, similarly situated person who has no qualification of this and with this training qualification, as my friend was saying. He didn't have that qualification. The honorable court has taken note of, that is in WPC 27414 of 17. That has been page 17. Order dated 6/8/2018. There, identical issue was there. If my lord, the brief fact of that case is at paragraph 5, page 18. Kindly have a glance. I am reading on slowly. The brief fact of the case are as follows. The petitioner has passed direct graduation degree from Director of Distant Education, Continuing Education, Utkal University for Open School System 2008, which degree does not require any pre-qualification. He has also passed Rashtrabhasha Ratna examination in Hindi in Rashtrabhasha Prachar Samiti Warda 2011. He also passed Acharya examination in Master Degree of Sanskrit from Rashtra Sanskrit Vidyapita, Deemed University, Tirupati, Andhra Pradesh with the first class distinction 2012. Thereafter, he has passed B.Ed examination first class from Rashtriya Sanskrit Vidyapit, Deemed University, Tirupati, Andhra Pradesh with distinction. He has obtained his birth certificate, Rashtravat birth certificate, UG, PSC, Dalang, Puri, registered his name in the employment registration certificate of Government of Odisha, Department of Regular Employment, Bhubaneswar. Utkal University has notified degree diplomas of other universities as equivalent with the corresponding degree diplomas Utkal University on a reciprocal basis, subject to ratification by Academic Council as per this said notification. Shiksha Shastri degree, Shiksha Acharya degree, Rashtriya Sanskrit Vidyapit, Tirupati, Andhra Pradesh has been recognized as equivalent to B.Ed degree of Utkal University. The Director of Secondary Education Odisha published an advertisement on 6/6/13 to fill up 4707 vacant post of various upgraded high schools, government high schools of the state. Pursuant to said order, District Education Officer Kendrapada published the advertisement in order to fill up 68 posts of Hindi teacher in Kendrapada district. In the said advertisement, the relevant eligibility condition for Hindi teacher indicated as follows. In case of Hindi teacher, a candidate must have obtained a bachelor degree from recognized university with Hindi as one of the elective subject or with Rashtrabhasa Ratna from Rashtrabhasa Prachar Samiti Wardha or with Shastri from Odisha Rashtrabhasa Parishad Puri or with Snatak equivalent to June 2005, the date up to which the temporary recognition has been granted from Hindi Shiksha Samiti Odisha Cuttack or an equivalent degree from recognized institution and Hindi Shiksha Parangat from Kendriya Hindi Sansthan Agra, BHED from Hindi Teacher Training Institute Cuttack, Hindi Teacher Training Certificate course from Hindi Teacher Training Institute Cuttack, Bhubaneswar and Sambalpur. If person with above qualification are not available, then person having the qualification of a bachelor degree from a recognized university with the Hindi as one of the elective subject or with a Rashtrabhasa Ratna from Prachar Samiti Wardha or with Shastri from Odisha Rashtrabhasa Parishad Puri with Snatak equivalent to 2005, the date up to which temporary recognition is granted from Hindi Shiksha Samiti Odisha Cuttack or equivalent degree from recognized institution and Hindi Shiksha Praveen from Kendriya Sansthan Agra will be considered. The document filed by the Council for the School and Mass Education Department reveals that the District Education Officer Kendrapada has published the notification on 14/8/2013 regarding provisional merit cum reject list of Kendrapada district for engagement of contract teachers against the advertisement of June 2013 for information of all concerned and for filing of the objection on or before 29/8/13 wherein the petitioner name was published as an entrant for which his application was not considered for engagement. After knowing the said fact, the petitioner has filed his objection and submitted all documents in respect of acquiring training qualification. In the said notification at class 7, it has reflected that candidate appointed applicant of Hindi post without possessing qualification of Parangat, BHAD, HTTC or Pravid have been rejected outright without scrutiny of other eligible conditions. Since no action was taken by the authorities on application of the petitioner, he approached the tribunal to consider his candidature at a 10 B.Ed candidate for the post of Hindi teacher in the upgraded government high school on contractual basis. Before the tribunal, the district education officer Kendrapada has filed its counter contending that, inter alia, that the applicant does not have Hindi teacher training nor BHED nor Parangat qualification as required pursuant to the advertisement. He has also not possessed Snatak or Hindi Shiksha Praveen qualification required under the relaxed category. Besides, he has not submitted the matriculation certificate, which is very much relevant to the date of birth, with passing Odia subject up to his high school level. The tribunal considered the respective plea of the parties, recorded a finding that the candidate has to fulfill all the criteria strictly as per the advertisement. However, the applicant does not fulfill the eligibility criteria. Accordingly, the tribunal has passed the impugn order.
Just a minute.
Just sorry.
decision on this point.
Yes, madam, therefore, this judgment, identical advertisement, also another in another case, before this honorable court, that went to Supreme Court, that order I have given.
We are prima facie of the view
Mine.
that there are two classes. One trained, having undergraduate qualification. Undergraduate qualification, BA and then BA, like that. But if someone has higher qualification of post-graduation and he has a particular qualification up to graduation also, BA Hindi, BA with Hindi as subject, BA honors in Hindi, and plus MA. So they are also eligible. And this is the class of the this will be the class of the candidates who are not trained. And for them only, that clause will apply, that they will have to undergo training for that clause cannot be applied to all of them, because that is the minimum qualification. If that clause is applied for all of them, then training requirement of BA will become meaningless.
No, that,
Mr. Das, what my lord says, that capital or in that resolution,
again.
capital or.
Hmm.
Prior to that, whatever qualification is, minimum qualification is prescribed, like Parangat, Ratna, blah, 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 blah.
This is one side.
That is untrained, that is trained. They have already undergone training. There is no necessity for sending them for another training.
Yeah.
Right?
Yeah.
The below part.
Yes.
After bachelor's degree with Hindi and MA, that part. So that part of persons having higher qualification, they do not have the training. So that is why this bracketed portion has come. That is what my lord.
That my lord is
I
saying,
say we are of
my lord's view
but
is
many what I have
this bracketed person only relate to that second part or. That is my lord is saying. Yes.
what
my lord is saying, that there are judgments contrary to the view which I am taking.
That is I am just showing, my lord. That I am showing.
All right. So if that is the situation, then it can be referred to a larger bench.
No, my lord, already applied in the Supreme Court. That I have given the Supreme Court. Kindly see that this judgment, Bapi Sahu case I was giving, this division bench judgment was, kindly have, my lord, let me come, this page 21 I was reading. My lord, just on what side, just skip the pages.
We also express our view.
Yes, madam. Yes, madam. I am much obliged. So now, my lord, this case was in a contempt, this order, division bench order. The division bench had set aside the order of the tribunal, who is identically placed that of the me, and directed for his appointment, and in a contempt they have complied. The person has already been employed. That document also I have given. The court has said, may I just complete that parameter so that it will be easier for you.
Please.
Well, kindly come to page 22. I have left it at page 27, now page 22. After quoting that qualification once again, my lord have held like this division bench. It further appears, shall I read, my lord? My lord. It further appears that Utkal University, Bani Vihar, Bhubaneswar has issued notification 23/4/2010 to effect that Shiksha Shastri degree, Shiksha Acharya degree of Rashtrabhasha Sanskrit Vidyapita Tirupati AP is equivalent to B.Ed degree of Utkal University. Since the training qualification, that is Shiksha Shastri, has been declared as equivalent qualification with B.Ed degree of Utkal University, non-consideration of the candidature of the petitioner to the post of Hindi teacher on the ground that Shiksha Shastri qualification has not been recognized to be a training qualification is not sustainable in IF law in view of the discussion made above. Since 40 posts of Hindi teacher are lying vacant in the district of Kendrapada, we set aside the impugn order and direct the opposite party to consider the case of the petitioner to the post of Hindi contact teacher in accordance with law, expeditiously so and so, so and so. This order, now kindly turn to page 25. It went in a contempt because that was not complied. After this order in the contempt by the division bench, where my lord Justice Raman was also the judge, that has been complied. Now, my lord, the person concerned has already been appointed on 14/7/22, that is page 28. Now, my lord, kindly come to another judgment which is went to Supreme Court. Same point, same. This is the Bapi Sau case is the previous advertisement, but this particular Arpana Sinha case, WPC 10616 of 2020, page 30. Page 30 mechanisms. That is WPC number 10616 of 2020. That Arpana Sinha's case identical to my case. Almost no, but this is carbon man. Her case also rejected in the tribunal. He came to this honorable court and this honorable court allowed that case. Against this order of this honorable court dated 7/9/2020, the state is gone in SLP.
No, that
The
is,
SLP was dismissed.
that is incriminate.
Pardon?
That the Supreme Court has not gone into the merits of the case.
But that was not
Declined to interfere in exercise of power under Article 136.
36. But that was not on limitation. That was not on limitation.
You cannot say that is merger.
Pardon?
You
No,
cannot say
this
that is
was
merger.
had it been on limitation.
You cannot say that is affirmation. of
That-
this course.
Yes, but that particular order has been confirmed by the honorable court.
No, not confirmed. Say Supreme Court says that we are not intending to interfere in exercise of Article 120, 136 of the Constitution.
My lord.
This is
So,
what the
so,
Supreme Court
so
says.
that order has been implemented. My honorable submission is that order of by the same state, yet the state is opposing me. Now, in respect of these two cases, at least I have got the copies. These two persons have been appointed by the interference of this honorable court in a division bench. Forget about the Supreme Court. In one case, they have gone to Supreme Court last and implemented. Other case in the contempt, they have implemented. At this stage of contempt matter, they have implemented. So now it is my turn. That is my case, madam. So far, my lord's view as expressed, I am obliged to my lord because at least my lord have a point. So I'm in a position to answer it. So my lord, my responsible submission is that bracketed person in the bold, my responsible submission subject to my lord's approval, it cannot be read in isolation only to that or person.
That is for a different reason. See, the first part is down the essential qualification,
My lord,
basic for consideration.
my lord,
The second point also lays down the essential qualification,
Right.
basic for consideration.
my lord.
Now, the third part under the bracketed applies to such persons who are not trained.
Right.
And second part is the class of the persons who are not trained. That is the,
My responsible submission is this bracketed person should apply to both because the training qualification is one of the consideration because there, my lord, my submission subject to my lords. Because the first part, even you will consider the first part also says you must have a graduation with 50% or 45%, whatever it is, and should have Hindi. That Parangat, they have stated that is or either for Parangat, Shiksha Shastri, from different institution, you must have Hindi qualification. Because what is the history of this Hindi teacher in state of Odisha? I want to clarify now. Initially, my lord, for the high school, only BA COVID was the qualification for Hindi teacher. Thereafter, it was enhanced to BA COVID with Ratna. That was the qualification. And accordingly, two scale of pay was prescribed. If somebody is appointed as metric COVID, he is having lesser pay. BA COVID higher scale with that Ratna. Thereafter, only in 2014, they have bring in this BHET, that Hindi qualification. Now in our state is been implemented only 16 seats in this Cuttack Institute. So thereafter, they have introduced this training qualification. And that moment, they have introduced a training scale also. So there are three types of Hindi teachers continuing in the school, high school. Now, after this training qualification introduced in 2014 onwards, this advertisement was for the first time. They have introduced that, yes, you must have a training qualification. That is why, my lord, what they have said, one part, you must be a BA with Ratna, Hindi qualification with.
Mr. Counsel, the advertisement, terms of the advertisement are very clear.
Yes, ma'am.
This and deals with training in teaching only and nothing else.
Yes, I do admit.
So basic qualification as prescribed in one and thereafter and training
Yes,
and then or for higher qualification.
Fine.
And then training, on the job training for those who had higher qualification, that is post graduation.
That is, my lords. Yes,
Advertisement is very clear.
my lord.
All right.
My response submission is,
Consider.
had this been the advertisement according to the state, my lord, I'm not quarreling with my lord's view. Just I'm saying what the state means. State means you must have BA Hindi and training qualification in Hindi also. Only that thereafter you can apply. So if this is the requirement in one side, once they use the word on-trained candidates shall have to undergo required training within the timeline. That training is also part to that training also. That is subject to my lord's approval. So now, my lord, and for the fact that therefore I have gone to these two judgments. These two persons also didn't have the qualification, BA. Only they have the BA as that of mine, a equivalent degree from another university. And that clause 1.b also takes care of a situation. If you have you have BA from outside university.
When was the advertisement issued?
27/10/2014.
Advertisement.
Yes, madam. This case is dragging from 2015, madam. This is the only person, and still then I've given, because other day other division bench also directed me, you give me the vacancy position if there is, because there is a direction in all these two cases and this case also. So there are a large number of vacancies, person has the qualification, he can be accommodated. Not going into any dispute, madam. That is, I have also given the update, the honorable teacher, because they are not getting trained persons. So now, currently also I have got the vacancy position, I have annexed it here. So there also the vacancy position are there. I filed an additional affidavit as per the order of my lord. And the vacancy position are still there. So that if others are accommodated, my response submission is this person, only now he is overaged. He is fighting out litigation from 2015, madam. And all other similar persons I have shown, whether this is confirmed or not confirmed by the division bench order of this honorable court, they have got the employment. They are in service. So these 4 persons should be considered. That is one of my prayer. Mine. That vacancy position also in the additional affidavit I have filed to this petition, I have given my own. With some other judgments, there are clear vacancy under Act 8, I have got it.
You that you may be strong on your point. But the question is, should we, particularly when some of the candidates have been appointed in the light of the directions issued by this court, should we interfere? Because this is process of 2000, it had started in 2014. If we enter into the question, which questions which you have raised and he has also raised, we may have to refer the matter to a larger bench for decision. And the matter shall again remain pending. It's a question of only one or few candidates.
Only one.
Just a minute. And then particularly when the Supreme Court declined to interfere with one of the orders of the court, that we understand that that will not amount to affirming the order of the court. It's a dismissal in limine. But why should we? Otherwise,
to that only I will have one answer. This person getting, I will state I will definitely not oppose to my lord's view that yes, if a person has been directed to be appointed. But my lord, what I pray honestly, I have gone through those two judgments cited by my learned friend. They are not similar at all. Number one, I can demonstrate it also. Number one, I don't stand on the way of my lord's not interfering with his getting appointment. But my lord, we can settle the law.
We will settle the law, but not in this case.
No, unless my lord.
Let it
Because there are
come.
many cases coming up on Monday even.
Let them be decided. This is 2014.
Of that 2014, some cases are now being, my lords are posted to
No,
Monday.
those are overage cases. I am there.
Just a minute.
Monday where my lord seniors were appearing and my friend Mr. Kundia was there. My lords are 5243. Same advertising.
All the matters are same also.
No, not
But
same.
here is a disqualification. We see. There they are over.
All right. Those cases are different. Those cases are different. In fact,
They are also.
every endeavor of the estate as also that of the court should be to give a quietus to these matters.
I will
pending
honestly
since
say my
2000.
law be settled. At least this, what is the stand you are taking? I don't. A person getting appointment, I will not. Definitely, I will be not. on.
No, we will say that we are not deciding those issues because of the finality, not finality because one judgment of this court has been affirmed by, not affirmed, has not been interfered by the Supreme Court, and therefore we will not go into all the submissions which you have done. We will record your submissions, but we will not decide them because that will lead to a situation where this litigation shall remain pending for next 20 years. We don't know.
Then my
Because again, a full bench may have to be constituted.
won't be required. These two cases from reading of it, I can demonstrate it is not equal at all.
Please show.
Yes, sir.
So according to you, the judgment on which he is placing reliance is not covered.
No. First one is relating to 2008.
Yes, that I accept.
Just
But the
Second one is 2014, but my lord, can you see the order? The order, at page 30. Page 31, the order of this honorable court. My lord, sir, page 31 of that compilation, my friend gave. Compilation of documents filed by the writ petition. Page 31. The second order. That is, this case relates to the 2014 recruitment matter. Accordingly, Mr. Mahapatra, my lord, I am reading para 51.
5.1.
Sorry, my lord, para 5.1. Accordingly, Mr. Mahapatra, on a standing council, produced the record of selection of candidates for the post of contractual Hindi teacher in government high school for the year 14-15 in 4 volumes today in court. On verification of record, it appears that in the new additional merit list, name of the opposite part number 1 appears at serial number 66, and in total has secured 220.6778 marks. In the merit list, it is submitted by Mr. Mahapatra that no candidate securing lesser marks than the petitioner has been appointed. He, however, submits that there is vacancy and the opposite part number 1 can be appointed accordingly. So, my lord, on this submission, the court, honorable court has allowed.
There was nothing in this case. Still the court directed for appointment. And this order has not been interfered with by Supreme Court.
No, there was no rejection of that man, my lord. This lady,
Yes.
WPC 10616 of 2020, there was no rejection. Here we have rejected his candidature.
So was in that case whether the candidate was qualified?
Yes.
He had the qualification.
Yes. What I say, my lord, since my lords are proposing, my lord may take up this case also on Monday. So that my lord will see all the cases.
Those matters are different.
Of the same recruitment.
Maybe same advertisement, other different issues.
overage. Overage. Relying on nice one.
Just a minute.
Sorry.
in order to ascertain the correctness of the contention of Mr. G. Misral and senior advocate to the effect that persons below the opposite party number 1 in the merit list were given appointment, ignoring the case of opposite party number 1, this court. So, my lord,
How are you relying on this order?
This order, my lord, he was not there. The qualification I verified from the case record of that case.
Yes, sir.
The same.
Don't do.
No, my lord, order, yes, order, my lord.
We don't go
See-
beyond the orders.
That there, my lord, this order, there he was not in the select list, that lady. And the government stand was that nobody else had been appointed.
Question of qualification. We were under the impression that the question of the same issue of qualification was there in the writ petition and the coordinate bench has decided. It is not there. So you cannot place.
Today's, my lord, one of my case, relying upon this Prashant Naik case, what is before my lord, I filed another case, relying on the honorable single judge, another honorable single judge has allowed that case.
Single judge will be doing
No,
that.
no, no, what, the kind of consequence, madam, sorry. The consequence is, I filed a contempt, there was no writ of it. Just I'm fact, madam.
Just-
That I'm bringing to my
Just,
lord.
let us understand the situation.
My,
This is the first division bench which is considering this aspect of
Yes,
the matter,
yes,
qualification
yes, yes.
aspect of the matter.
yes, yes. That's,
No, this aspect, this issue has not been decided anywhere, by any coordinate bench.
no, that was in that other case, though it is a different advertisement, but the issue was almost the same. That
Advertisement,
period-
whoever.
No,
Yes,
just previous. I am in 2014, that was in 2013, in that BAPI, the 27414 of 17,
where is that?
that is the 17 minor. This is with regard to the qualification, equivalence of B.Ed. That is there, page 17. That I was reading, minor. WPC 27414 of 17,
Where
Party
is that?
House case.
Where is that?
Minor, page 17.
Of the compilation?
Yes, ma'am. Order dated 6/8/2018 of the division. Honorable division man, there, madam, the equivalent that B.Ed qualification was in the subject matter as of my case, madam. He has got it from Andhra University, I got it from Jammu University. But the honorable court has said, because it is equivalent qualification, Utkal University has given the, declared the acceptance.
No, that's.
Shall I read once again, madam, the fact of that case? Only 2-3 lines I will read, madam.
Yes,
Here, my lord, that is at page 5, brief fact of the case, para 5,
Page-
page 18. Towards middle, para 5 towards middle. 1, 2, 3, 4, 5, 6, 7, 8. 8 line from the para 5, middle, my lord. Therefore, thereafter, he has also passed B.Ed examination in first class from Rashtriya Sanskrit Vidyapitha Deemed University, Tirupati, Andhra Pradesh, with distinction year 2012. Start from this. I have passed it from Jammu. He has obtained birth certificate. This is not important, my lord. Now, then thereafter, Utkal University has notified 4 lines from the bottom. Utkal University notified degree diplomas of other universities as equivalent with the corresponding diploma of Utkal University on reciprocal basis, subject to ratification by Academic Council as per the said notification. And taking note of this, my lord, kindly turn to page 20. The document, after the quoting person, the documents filed by Learned Standing Council for School and Mass Education Department reveal that District Education Officer Kendrapada has published a notification on 14/8/2013 regarding provisional merit cum reject list of Kendrapada district for engagement of contract teacher against the advertisement of June 2013 for information all concerned and for filling of objection or before 29/8/13, wherein the petitioner name was published as untrained, for which his application was not considered for engagement. After knowing this said fact, the petitioner has filed his objection and submitted all the documents in respect of acquiring training qualification. In the said notification at class 7, it was reflected that candidature of untrained applicant for Hindi post without possessing qualification of Parangat BHED, HTTC or Praveen have been rejected throughout without scrutiny of other eligibility condition. Since no action was taken by the authorities on the application of the petitioner, he approached the tribunal to consider his candidature as a trained B.Ed candidate for the post of Hindi teacher in the upgraded government high schools on contractual basis. Before the tribunal, the district education officer Kendrapada has filed its counter contending inter alia that applicant does not have Hindi teacher training nor BHED nor Parangat qualification as required pursuant to the advertisement. He has also not possessed Snatak or Hindi Shiksha Parveen qualification required under the relaxed category. Besides, he has not submitted the matriculation certificate, which is very much relevant for the date of birth, which is possessing Odia subject of his high school qualification. The tribunal, on consideration of the respective plea of the parties, recorded a finding that candidate has fulfilled all the criteria strictly as per the advertisement. However, the applicant does not fulfill the eligibility criteria. Accordingly, the tribunal has passed the impugn order rejecting the prayer of the petitioner. On perusal of records, it appears that the government of Odisha in the Department of School and Mass Education Department have issued a resolution on 18/2008 regarding introducing common qualification course of Hindi teacher in government, fully aided block grant recognized high school of the state with one identical scale of pay plus 10-11 of the said resolution stipulated thus. Now, my lord, thereafter. It further appears that Utkal University, Bangalore, Bhubaneswar has issued a notification on 23/4/2010 to effect that Shiksha Shastri degree, Shiksha Acharya degree of Rashtriya Sanskrit Vidyapith Tirupati, AP, is equivalent to B.Ed degree of Utkal University. Since the training qualification, that is the Shiksha Shastri, has been declared as equivalent qualification of B.Ed degree of Utkal University, non-consideration of the candidature of the petitioner for the post of Hindi teacher on the ground that Shiksha Shastri qualification has not been recognized to be a training qualification is not sustainable in the eye of law. This is my identical fact I am saying, my lord. Now, in view of the discussion made here in above, since 40 posts of Hindi teacher are lying vacant in the district of Kendrapada, we set aside the impugn order and direct the opposite parties to consider the case of the petitioner for the post of Hindi contract teacher in accordance with law as expedient possible, preferably within a period of 2 months from the date of production of the certificate copy of the order. And this order, my lord, I have complied because of the contempt. The contempt order also I have given. So my response submission, though it is the previous year, 2013, but this he got a certificate from Andhra University, B.Ed certificate. I got it from Jammu University. But the same Utkal University declared that is equivalent, which was taken note of my mind.
Was there in that advertisement?
Say that is there, man. I cannot, I say that is, but in the same post, man. This is the previous year, I am in the next year.
Advertisement was same.
Almost same, man. That
Almost, there is lot of difference between almost and same.
that quoted it, that quoted it. My lord, is subject to my lord's approval. I have read it. That is quoted at page 19. That is quoted, man. That quoted it. To me, my lord, same. Subject to my lord's approval. So since other person had got appointment and he got in 2022, my lord. But this is 51. And that also we consider. Hardly I can walk if my lord.
We are bound by law.
Yes, ma'am. Oblige.
Whatever that say, that the law says, we will be doing.
My
Obliged.
Anything else?
Well, I will simply say this judgment doesn't apply. This is the 2008 resolution. We are in 2014 resolution.
Please give your brief notes because
Okay.
we have at times tendency of forgetting the points which you
by Monday, ma'am.
by Monday.
I'll file a note.
But so order is reserved.
My lords, give me a present hearing. Obliged.
That is our duty.
But we only want that. We want that only. Because our duty is over after that.
Yes. Item number 15.
Item, my lord, I am for the respondent.
Yes, sir.
I am for the respondent.
In this case, notice has been issued. Your Lordship has issued notice on 6/4/2023. Admitted fact, there is a delay of 243 days. And if your Lordship will condone our
justification.
yes, my lord, if you that I am submitting, if your Lordship will condone our delay, then I can place the merit. And in limitation petition, I have seen that there is no sufficient ground has been stated. Your Lordship.
Then
Yes, for that. Your Lordship may see my limitation petition. 38 IA number 957 of 2020.
IA number.
See 957 of 2023.
This. For it appeal. Is time barred. First off, there is delay of 340 days.
In fact, that is 274 days. What I have calculated, it would be 273 days.
Our
If it
registry
is
points out, our registry points out 311 days.
That I am saying that it will be 273 days if it is excluded that 90 days.
90 days.
Is excluded 90, it is starts from 1/6, then it will be 273 days. If it
90 days.
that I am saying that from 1/6/2022. If it is calculated, it is calculated from 1/6/2022, then it will be 273 days. If it is calculated from the 30 days after the date of the order, then 344 days. 30 days my lord limitation for filing writ appeal. Order was first on 25/3/2022.
Order was passed on.
25/3/2022, my lord.
So limitation would start from
Starts from 24.
3/2023.
22, my lord. 24/4/2022.
Yes, 25/4/2022.
My lord, it was filed on 28/2/2023.
28/2/2023.
If it is calculated from that 24/4/2023, then it is 344 days. If it will be calculated from 1/6, then 60 days. There is some.
Why 1/6?
Because of the Honorable Apex Court's judgment that in that COVID period, that till 1/6, it was covered till 1/6. So that's why I am saying from 1/6.
Lord, Apex Court judgment came on 10/1/22. 10/1/22.
No, 28/2/2022. 90 days from 28/2/2022.
Honorable Apex Court judgment came on 10/1/2022,
Yes.
saying that from 28 February, you have 90 days period, whatever you have not taken action
Yes.
without filing. So this judgment being passed in March 2022.
So, but we are covered till 1/6. That I am submitting.
How will that apply?
90 days from 28.
Perhaps you have misread that judgment.
I have given that. Anyway, my lord, this is the limitation, but in our limitation petition, I have seen that the grounds not sufficient. Explain, your lordship.
The officer has pointed out that the appeal is delayed by that there is delay of the officer has pointed out that there is delay of 311 days.
311 days.
After 311 days
normal period.
in receiving the appeal. Learned counsel appearing on behalf of the state of Odisha / appellant has submitted that the there is no proper computation of the period of delay. And in fact, the appeal, in fact, there is delay of how many days according to you?
274 days.
274 days.
My lord, in the petition, it has not been mentioned. The days has not been mentioned.
All right.
That my lord is dismissing.
Stop. Next. The only explanation is submitted for delay in the present application, IA number 957, for condonation of delay is as under paragraph 5. Full stop. We are not at all satisfied with what has been stated here in what has been stated in the application seeking condonation of delay. Full stop. It cannot be said that the appellant had sufficient cause for not referring the appeal within the stipulated time. Full stop. The delay having been not duly explained, this application deserves to be dismissed. Consequently, the appeal stands dismissed as time barred.
Item 16.
Well, I'm sorry, I have one copy, my lord's order. That Bindu Sagar. So I'm sorry, one,
Rehabilitation assistance.
yes, my lord's order. One copy I have, my lord, I don't make any good.
Yes.
Publish.
Item 17.
Certain my lords. Pardon my lords, I am appealing for the respondent, my lords. The state has filed an affidavit annexing a fresh inquiry report, my lords. I pray for a short adjournment to file a reply, my
First
lords.
inquiry report in appeal.
My lords.
Yes.
My lord, I have filed that additional affidavit, I have served copy on him. He wants praise for that.
As requested on behalf of the respondent to consider the additional affidavit which has been filed on behalf of the applicant. Listen, matter on, when do you want?
It's 1 week, my lords.
2 weeks.
Item 18. Item number 18.
Challenging Annex 7, the order passed with a single judge. Writ application was rejected on the ground that there 6 years delay. Case 93, my lord, thanks.
6 days of delay. Your appeal is barred by.
The honorable single judge said my appeal is, writ application is barred by delay, limitation now. Case 93. The operating part, my lord, starts case 95.
Which annexure?
Annex 7, my lord.
Where is that?
My lord, 96, para 6, my lord. Page 96, paragraph 6. Therefore, this court is not inclined.
Yes, this is not barred by. This is because of delay and latches your writ application.
The writ application dismissed, my lord.
Then,
So my respectful submission, my lord, the order which was challenged before the honorable single judge, that is my 22/6/2016.
yes.
My lord, earlier petitioner approached the Lawrence State Administrative Tribunal, my lord. It my lord, see page 40, Annex 8.
Annexure 8.
Annex 8, my lord, page 40. Earlier he approached claiming trained graduate scale of 10.
Annexure 8, Mr. Annexure 8.
8, my lord.
Your annexure 7 is at page
Sorry, page 40, my lord. That is internal annexure to the writ application. Page 40, my lord.
of the writ petition.
I have annexed the entire writ application.
You have annexed the writ petition.
Page
All
40,
right.
my lord. Page 40.
Which annexure?
My lord, can you see page 40? It's annexure 1, the entire writ application.
Yes. Yes, annexure 8. Yes.
I approached the Learned Tribunal in 2014, my lord. OA number 2838C of 2014, claiming graduate scale of pay in view of the government circular dated 2012, my lord. This was disposed of on 20th January 2015 with a direction to the state government to consider his grievance in accordance with that guideline, my lord. Since that was not complied, I filed a contempt application before the Learned Administrative Tribunal, my lord. That is at page 41. That contempt application was pending in 2016, my lord, that was disposed of. A compliance affidavit was filed that we have rejected your grievance. Thereafter, my lord, contempt application was dropped. Since that they have rejected with a liberty, you challenge the order of the rejection, my lord. Thereafter, in 2017, I filed another original application with a prayer in page 52, OA number 2023C of 2017. Though I mentioned in the order of rejection in the said original application, but specifically I was not prayed for quashing, though I prayed for that similar prayer which was prayed in first original application. That original application was transferred in abolition of the Administrative Tribunal in 2019, and it was again renumbered as WBC OSC 2023 of 17, page 53. And this Honorable Court gave a liberty on 12/8/21. Since the prayer, that is some defect in the prayer, liberty was granted to you withdraw the writ application with a liberty to file a better particulars with better averment, my lord. After withdrawal of the writ application, I filed the writ application before this Honorable Court, which was dismissed by the Honorable Single Judge on the ground that the order which was impugned was filed after 6 years. That is the only.
So how much time did you take in filing your second writ application?
See, the writ application was withdrawn on August 21, 12/8/21. I filed writ application in 2022, my 2022.
Yes.
My lord, actually, this
Have you-
brief is wrongly allotted to me. I should not appear in his case. So,
Notices have been issued. Notices?
Notices, my lord. In this case, notices not.
Issue notice. Okay, okay. So did you challenge the order of the tribunal passed in 2016 here?
In the present writ appeal, my lord.
Yes.
No, my lord. I'm challenging the order dated 30th June 2023 by the Honorable Single Judge, and page 93.
So you had approached the tribunal for framing of rules.
I approached the Learned Tribunal after my rejection. After the rejection of the government, page 46, I approached the Learned Tribunal. Since they rejected on the ground that there is no rules, though benefit was extended to some other persons, I approached the Honorable Learned Tribunal, my lord. Since that was transferred to this Honorable Court, since a prayer was defective, I pray only to frame the rules and extend the benefit. And I was not prayed for passing of that annexer, that document.
No, even the High Court cannot issue direction for framing of rules.
No, no, the rules is there. Can you see the page 46? The order impugned before the Learned Tribunal. Page 46.
Sir, you are saying that you are seeking direction for framing of rules.
That prayer was since defective, I withdraw the writ application with a liberty, my lord. I withdraw the writ application after the transfer of the original application. Since that was a defective in prayer, I withdraw the writ application with a prayer to file a better particulars with better.
So what did you do in the second writ application?
I challenged the order of rejection at page 46 before the present writ application.
And did not seek any direction for framing of
No.
rules? So what is your ground to have TG scale of pay?
My ground, my lord, since the page 35, the government formulated guideline to extend the benefit to the persons. Petitioner was appointed in 1980 in a trained intermediate post, my lord. In 82, he completed his BEd course, my lord. Government formulated those persons, those are continuing having not qualification of BEd. If subsequently they have the qualification of BEd, they will get the trained scale of pay from the date they acquire the qualification. So I retired in March 2011. The circular came from 25 October 12, indicating therein that those persons are continuing by that time or they left the institution, they have to get the benefit notionally. So I approached the Learned Tribunal, consider my case in view of this circular issued by the state government. That was the rejected. Subsequently, I approached in 2022, my lord, after withdrawal of the writ application.
Is he not entitled?
But so I take given because
All right. Let us see. Issue notice. Issue notice. Learned AGA accepts notice on behalf of the respondents. Let requisite number of copies of the memo of appeal be served upon him by Monday.
By Monday, my.
This is appeal after, this is appeal of 8 weeks.
Item number 19.
Is there any delay? Is there any delay in filing?
No, my lord.
Madam, in item 19, I was only praying for next week. I know my learned senior appearing for the private respondent was opposing yesterday. I'm only praying for next week because I was not keeping well. He has filed a reply to my writ appeal, annexing some documents. I'll file it by Monday only. I humbly pray, my lord, your lordship may take up on Thursday. But Friday is a holiday. If you're subject to your lordship's kind consideration, I'm praying for this, madam.
So why was
My learned senior is there for the private opposite party.
he is your senior?
He is senior to me. Therefore, I said, my lord,
It looks young.
my lord. The land council appearing for the respondent number, private respondent, my lord. I'm sorry, my lord, I stand corrected. My lord, what has happened, the writ petition has been disposed of without hearing me, though a right had accrued in my favor. I'll assist your lordship. I am only praying for next week, madam.
No, but if he agrees, otherwise.
My lord, now it is 1-5 also, my lord, I am praying for next week only, madam. Next Thursday, your lordship may take up, I'll assist your lordship. I'll only.
Because this melody is praying for something, melody which I don't want to. The only thing, my problem is, melody, this interim order is continuing since 19/10/2023, my lord. And we are in the month of.
You have filed an application for vacating.
I have filed an application for vacation of this. I have given all the copies.
So when was the order passed?
19/10/2023.
In your presence?
My lord?
In your presence?
No.
In presence of the STA council, it was passed.
That's what.
And when did you make your application, or
Now this, I have filed counter saying that the honorable court said.
whether have you filed any application seeking vacation of the?
Yes, my lord. That was filed very late, madam. Because I made
When
16 to 2024.
16 to. Then a constitution. This thing. The position under Article 226(3). So if your application is not decided, then your interim order shall stand vacated as against him.
But I think my learned friend will not oppose till next Thursday only, madam.
He is not opposing. We are bound by the constitutional provision. So by operation of the constitutional provision, the states.
But that your lordship, IA is pending, your lordship can extend it, madam.
No, we cannot extend it. This is the requirement of the constitution. The provision, constitutional provision.
I'll place it, my lord, then. I'll
As you
place it.
wish. You have still time.
I'll place it.
It is 29. 15 days. You filed on 16th.
Right.
So we have a duty to decide by Monday. At the maximum, we can extend to Monday.
Right.
As requested on behalf of the petitioner, appellant listens matter on Monday.
Item 20. Madam, the interim order is there, madam.
Interim orders are.
Right.
They are not saying anything on that.
Right.
Item 20.
The lawsuit directed me produce that Article 11 of 2004. That section 33B has not been, my lord, inserted in that act, amendment act.
Yes.
Therefore, this power, my lord, my humble submission, the power has not been vested with the registrar. Under section 33B, which was omitted or repealed, deleted from the provision to formulate this rule.
No, what was the question? We are just forgetting.
I have, my lord, challenged the virus of the Odisha. That is the Odisha. The common cadre of the chief executive officers of PACS, SCS, LAPS, and FSCS rules 2023, my lord. I have taken that specific ground that the power has not been vested with the, in the statute with the register of cooperative society to frame that rule. That common cadre.
Use the mic.
Pardon? Mic case. My lord, my humble submission to you before lordship that the registrar framed this rule
Under
You are,
section 33B,
you are challenging violation of which provision?
I have challenged that, that 33B, the power has not been vested, not virus, my lord. The 33B power is not vested with the registrar, that has been omitted to frame that rule. Therefore, the rule framed by the registrar is without jurisdiction.
Where is that? Book count. Which book you are referring to?
My lord, I am referring to the book that in the latest book they say that it has been, my lord, I am giving the first book to your losses. In 2002,
No, what is your case?
my case is that a common cadre rule has been framed,
Common cadre.
common cadre rule. For the PACs, the executive, the chief executive of primary cooperative societies. This rule has been framed by exercising the power by the registered cooperative societies under section 33B of the Orissa Cooperative Society Act 1962.
Just a
This provision,
Just a minute.
prior to 2004 amendment,
So you
prior
are,
to 2004 amendment,
so you are challenging rules.
rules, my lord.
Where are they? Where are
That
the
rule under Annexure 6, I have.
Annexure 6?
I'm taking to a losses page 36.
Huh?
Annexure 5, my lord. I'm
Annexure
taking to 5 at page Annexure 30, at page 36, my lord.
So if in place of rules we read regulation, then what will happen?
Regulations, my lord. Regulation can be passed by, my lord, by the government, the
No,
state
in
government.
place of, if in place of rules,
No, yes,
or if we substitute
by regulation, what
with the-
regulation,
Huh?
constitute or what regulation?
Then
Regulation is framed by, my lord, by government of Odisha, not by
now
the
come to section 33B.
B.
Please come.
Yes. My lord, prior to 2004 amendment of the
Forget 2004.
amendment,
Come
I have given that Act 1 of 11 of 2004, my lord, amendment.
Please come to
The new book, my lord. In new book, it has been published by the OLR, in which the 33B has been mentioned to have been introduced by amendment by Odisha Act 11 of 2004, my lord. Page 34, page 77, my lord. Page 77 of this book, my lord.
So this is your submission that the registrar does not have any power to make rules.
Yes,
This is your submission.
yes, my lord.
So let us come.
That your losses can come to 34B, which has been
33B, you are saying?
33B, my lord.
Yes,
33B.
right.
My lord, here, this provision, according to this, my book, it has been brought by way of amendment of Odisha Act 11 of 2004, my lord.
So what is wrong with the rule?
Rules, my lord. That has not been, my lord, inserted in the rule, my lord.
That is there. Come to
That
subsection 2.
section 33B
No,
was not there, my
You
lord.
mean to say that this book printing is wrong
Wrong, my lord.
and you have brought to our notice
Yes.
this. Instead of this, you should have produced the gazette notification itself. This is also not gazette notification. This is OLR publication and this is also OLR publication.
So this
So-
is incorrect according to you.
This is not there in the application.
This may be Original thing.
Gadget, my lord, I have to get it from your lordship's library only.
So
I'll get it from
both the books are published by one
one
publisher.
One publisher.
So the publisher has put the footnote
Yes.
as if it has come to exist in the statute book by virtue of Odisha Act number 11 of 2004. At 33B also he is putting the same.
Sure.
And his publication which he has extracted from the Gazette and put
And printed it.
he has made it
in the
in a
journal.
text.
In the journal.
So, so there 33B is not reflected.
Replay.
So you are saying that 33B is never brought to statute book
By your comment.
by virtue of Odisha Act
11 of
2004.
2004.
That we can verify from the Gazette only.
Only, my lord, I will bring that. You will also keep it next week. I will bring to your lordship's library. My lord.
We don't have any.
On behalf of the.
I will bring that from your
Then
lordship.
we may be issuing some direction to such publications. If they are publishing,
No, this another publication, my lord. There it has been stated, it has been omitted, my lord. By Act 11 of 2004, my lord. Two publications are there with three publications. It has been mentioned, it has been omitted.
it has been omitted when?
By Act of 11 of 2004. Prior
Act of 11 of 2004, this is what
That
you are saying.
is not there, but up to before that 2004 Amendment Act, my lord, this 33B it did show something else, my lord. That is 33B.
So whether you put everything on the website or not.
My lord, we should be putting everything to option. I will take, if my lord,
Seek instructions.
My lord.
It's a serious matter.
my lord.
As requested on behalf of the parties, this matter on next week, Friday. So as to enable them to bring on record the Gazette notification regarding Odisha Gazette notification of Odisha Act 11 of 2004. That is the Odisha Cooperative Societies Bracketed Amendment Act 2004.
My lord directed me to produce.
Both of you.
My lord.
And you tell your department that all such notifications should be placed.
My lord.
All the acts and bylaws and whichever notification has some statutory force should be there on the website.
My lord.
So
Most of the time it's not available in the website, my lord. Therefore.
available.
Most of the time these notifications and gadgets are not available in the
That will be
website, my
available.
lord.
Number one.
May I please? It's for modification of your lordship's order dated 9/7/2021.
Yes.
The lordships will take up that order at para 5. But initially it was the as Additional Commissioner Settlement Consolidation, Bhubaneswar. Thereafter, the jurisdictions were changed, it went to Balasore. Thereafter, now it has gone to Bhadrak, and they are not, they should actually transfer it, they are not transferring it. So I need a modification so that in place of
Balasar, it should be Bhadrak.
And if that is again transferred, then
They should do it. The state government should transfer the records. They are not transferring the records.
why should we pass any order?
So I don't know whether they are alleging that or whether it's a fact or bifurcation that they got an order as back in 2021. Now they have filed this application in 23 saying that now it has been the jurisdiction has been outlawed from Balasar to Bhadrak.
So why have they come to the High Court?
So I don't know whether at the time.
No, this is what they are saying.
Yes. And when was the bifurcation is not
So whenever the bifurcation was done, you were required to transfer.
then I have to take instruction whether.
We will not modify the order. Order does not require any modification.
I think once it will be modified.
Once it has been modified to Balasar. Now again, they have bifurcated.
We will not do
They
it.
are now seeking.
Please don't compel us to do.
No, I don't want that, but now they're saying that originally it was Bhubaneswar.
If you don't do, we will be doing, but we will be doing differently.
No, obviously, if the jurisdiction is transferred, automatically record should be transferred. There is no dispute to that effect.
What happened?
I will not dispute there. If it has been done, I will say that it is also done.
That is why last date we had asked you to take instructions.
But because there are private parties and one more.
No, even there were private parties, you were asked to get
No,
instructions
I-
because of this problem.
That was only within one week I can get instruction, but one more thing they prayed for. They stated that instead of an appeal, a revision should be disposed of.
What
What I don't know.
has-
so-
What has happened is that the revision case was set aside. 3 revisions were filed. 1 writ was filed against that, so far as the private opposite parties are concerned. So all the 3 common order was set aside, so we went in appeal. This court held, only 1 revision should be sent back for stress disposal. So instead of writing the revision case number, appeal case number has been reflected in para 6. That is why I have sought that instead of appeal case number 20 of 85, it should be consolidation revision case number 148 of 93. Because the para 6.
Yes.
If your lordship last line 6 before proceeding to hear appeal case number.
This matter on 2 weeks. So let an affidavit be filed on behalf of the state dealing with the assertions made in the present application seeking modification. Take your stand in that affidavit.
Item number 2.
May I please, your lordship? The appellant has been convicted under section 302.
What happened? Yes.
Appellant custody since 14/7/2012, more than about 12 years in custody. 11 year 6 months about is in custody, and he is convicted under section 302 IPC, sentenced to life imprisonment. And case the case is that the petitioner, the appellant is the deceased is the uncle nephew of the deceased.
Paper book ready here. Huh? Ready. We can hear it finally.
2 sets of paper books, yes. What should you-
Paper book is ready.
My
You
lord.
can hear it finally.
I
Whenever you want.
have also received the paper book as your lordship, please.
Whenever, when you say, we fix a date on any Friday.
Your lordship, my next Friday
Friday?
is not there.
Next,
is
there is no Friday.
no Friday.
No, next Friday means when the
As your lordship, please.
When you are-
I'm ready to.
learned counsel appearing on behalf of the appellant states that instead of considering the appellant's prayer for suspension of sentence, the hearing of the appeal itself, final hearing of the appeal itself may be expedited, as the appellant is in custody for last 12 years.
About 12 years.
For about 12 years. So list this matter on Friday, 15th. Friday, second half. Friday, second half. Same bench. Okay. For final hearing. Yes.
Item number 3. If it could not be if it could not be taken up, then also kindly consider my bail application that is lying
That day.
on that day.
Why are you seeing it today?
Yes, yes. Item number 3.
This is also imprisonment for life under section 302. In custody since 13/9/11. My bail application was rejected last in 2020. Thereafter, the bench was not available. It has never been taken up. I heard the earlier matter, I agree to that. Only have a small prayer, minors. I was encountered 2 bullets on my knee and ankle. Thereafter, it has deteriorated during all this period. This is the only shun. I need some breathing space, at least interim bail for a month or so, and fix a date for hearing. I undertake not to pray for ourselves.
There is no application for interim bail.
It's there. Since 21, it's pending.
Okay. It's on
IA number, yes, I don't dispute that. I heard my lord's opinion. I am not disputing anything. I am only saying that because of that records are there available attached from the jail. I have attached IA number 146 of 21 is still, and plus his old parents are there, the only shun. I need some breathing space. Maybe a month, my lords, and a date will be fixed. First week of April, 5th April. On that day, I undertake, I will not pray for them.
We can suspend the sentence. Hear the appeal finally. You suffer injury.
Not, Millards, because of an encounter. I was encountered by the police. They fired at me 2 bullets on the ankle and knee.
That is your submission that you were encountered by the police.
That is the case, Millards. That is the case. I was encountered in another case in Bhubaneswar. Then in this case, I was taken on remand. That is the case, Millards.
Also,
Nice part of the story.
after this occurrence, you were not arrested.
Right.
After you were arrested in connection with another case and taken on remand in this case. So it is
Under arms act, now I have been acquitted in that case. In this case, I was taken on remand.
This case also Arms Act is there because the
Yes.
allegation is you have killed him by gun.
That case, the one man, he stated that I have given him the armaments. That is the reason I was tagged in that case. And in that case, I was encountered. Then taken in remand in this case.
Yes, shot
That
at
case,
him.
I have acquitted because no
Officer.
co-accused statement only, nothing was there.
How old are you?
That's at present.
39 and
39
17.
now.
44, 46, 47.
2017, 39. 52.
39.
45.
IA number 146 of 21.
We will see on the next Friday. We will hear it finally. If you come with your written notes, pointed the specific points, we can decide the matter on next Friday itself.
No, I don't dispute. This is an additional prayer, my lord.
Additional fair, we understand.
Some breathing space if can be. For a
Item of
5th April.
5th April, we will be hearing 2 criminal appeals. This appeal and that appeal.
Okay.
Please come ready with your short submissions, the point which is involved. You may say that you don't have any case.
Unless the
Okay.
records say so, my lords.
Otherwise, you may have.
Item number 4.
May please your lordship, Lord. May please your lordship, Lord. The petitioner has been in custody since 17 July 2006. He has been in incarceration till date. 17 July 2016, Lord, 16. He has been in incarceration for offense under section 302 and sentenced to undergo RI, Lord. Life
So we are trying
imprisonment.
to expedite hearing of such criminal appeals where the appellants have remained in custody for 7 years or more.
Yes.
So please wait for some time. We are not passing any order on your interlocutory application.
In a short date, Lord, I will prepare a short note of submission.
We will list this appeal on 6 weeks for this court to consider expediting final hearing of the appeal.
Item number 5. Last occasion, your lordship's director, was
Committee.
in this case, I didn't receive any instruction. Let's say give more time. In the meantime, I'll request my grand friend to serve the original copy. After disposal of the long period matter has come, they only file a I copy. I'll serve a copy. Other copy, otherwise I can make it direction, I can to use. These records are not available, this old record after disposal of long.
Old record, main thing you were supposed to find out about that anomaly committee, because normally that should not be in existence for so long.
Anomaly committee cannot continue for so long.
Next week, let's make 10 days time.
Petition copy. Already served.
No, I have.
Let a copy of the application be served upon the Deputy Solicitor General of India by
Monday.
By Monday. Let's the case on for same day.
Published. Resolution item number 1.
May I please, my lords? My lords, this is application under 11(6) of the Arbitration and Conciliation Act, my lord, for appointment of arbitrator. My lords, kindly turn to page 14. This is the agreement where clause for arbitration is provided. Clause 17 at page 14, my lords.
Who is for the other side?
My lord, fresh matter, notice is to go, my.
Notice. Okay.
Item 2.
Lordship, passable, lordship. Passable. Password. Monday or Friday. As requested on behalf of the petitioner, close this case on Friday.
Item number 3.
My lord, this is regarding appointment of an arbitrator, my lord. My lord, agreement is at page number 12. And dispute settlement clause is at page number 46, my lord.
Notice?
My lord?
Notice will go?
Yes, my lord.
Last page 46.
Well, that's as I appear for the state.
Yes.
For the response. As I appear for the respondents. I appear for the respondent. The state is the respondent. I'll accept notice on behalf of.
Oh, but the dispute is between him and state.
Please, my lord. Yes, my lord.
Then notice, no notice is
No
required.
notice. I'll accept notice.
Yes. So which arbitrator? So whether any attempt was made to settle the dispute through mutual amicable
No,
consent?
my lord, no reply whatsoever was given to us from their side.
Had you attempted?
Yes, my lord. My lord, we have at multiple occasions have sent them notice, and also regarding dispute settlement, my lord, may come to page number 222, my lord. My lord, on 30th 10/2022, my lord, we have sent a request for amicable settlement of the matter, my lord.
You file a reply.
I'll file, please, my lord.
And then come with some common name.
Lord. Yes, my lord. Please, my lord.
All right.
Yes, please, my lord.
As requested on behalf of the state learned council, so and so accept notice on behalf of the opposite parties. What do you call? Opposite party number one, opposite party. It seeks 3 weeks time.
Please, my lord.
And council seeks 3 weeks time to file counter affidavit on behalf of the opposite party. Place this matter on 3 weeks.
Item number 4.
Obliged, my lord.
May it please, Millards. Millards, IA number 2 on your lordship's board, IA number 2 of 2024, Millards, flag 30. At flag 30, Millards, is a application seeking extension of 6 months period, Millards, for the passing of the arbitral award. There, in this case, Millards, my lord, Honorable Justice, late Honorable Justice D.P. Mahapatra, former judge of Supreme Court, Millards, was appointed as the arbitrator. Thereafter, Millards, while the proceedings were continuing, unfortunately, we lost him. And thereafter, your lordships were pleased to appoint my lord, Honorable Justice A.K. Rath, Dr. A.K. Rath, former judge of this honorable court, along with 2 other members, arbitrators nominated by the respective parties. Now, the matter is going on, Millards. Pleadings, etc., is completely over. Only arguments are going on now. In fact, Millards, on last few occasions, arguments are being advanced and the matter is remaining parted. At this juncture, Millards, since the time period, Millards, is expiring, therefore, Millards, I have come before your lordship seeking 6 months extension to conclude the arbitral proceedings and pass the arbitral award, Millards.
Under which jurisdiction?
Millards, under section 29A, Millards. 29A, Millards, I have approached your lordships for extension of that time period. Millards, 29A4 says that, Millards, we can approach, Millards. Millards, I am quite alive to the questions.
So please, you will have to address that question.
I am ready, Millards. I am ready. Millards, if your lordships, may I straight away take your lordships to the problem, Millards, what your lordships are citing, Millards, Millards, I am quite alive to that issue, Millards. If I may kindly take your lordships to 29A.
Yes.
Millards, 29A4.
Yeah.
If the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court, this court is what is the area that I have to address, Millards, your lordships. Unless the court has either prior to or after the expiry of the period so specified, extended the period. Now, if I may take your lordships to the definition of court under 2(1)(e).
Yes.
Court means in the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of suit but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. Plus, this is with relation to domestic arbitration. With relation to domestic arbitration is the principal civil court. That's what it means. Plus. But Millets, if I may kindly draw your lordship's attention to how section 2(1) starts. May I read, Millets? Definitions. Subsection 1. In this part, unless the context otherwise requires. So, Millets, here, what is important is to be seen whether the context requires court to be considered as a principal civil court or to be court, the court denotes this honorable court, which under the jurisdiction of section 11(6). Now, that particular aspect, Millets, has been considered in quite a number of judgments, Millets. With your lordship's leave, Millets, if I may, straight away, because this is the seminal issue before your lordships. So these judgments, Millets, will throw a lot of light on this particular aspect. If I may take your lordships to the judgment of Delhi High Court. Millets, although I am aware Delhi has yes, Millets, I was just addressing that. Although Millets, Delhi High Court exercises original jurisdiction, unlike the Orissa High Court. But Millets, this is decided, Millets, forgetting without being influenced by the fact that it has original jurisdiction. So therefore, the question that has been decided is without any reference to the fact that it is having original jurisdiction. So Millets, not in an original jurisdiction, the Delhi High Court has decided this. So I'll cite that. If I all right. If I may cite, Millets, it will make things clear, Millets. Plus, this is Delhi Development Authority, DDA versus Tarachand Sumit Construction Company. Millets, if I may kindly draw your lordship's attention to para 3, Millets.
Yes.
The petitioner has filed the present petition under section 29A of the Arbitration and Conciliation Act for extension of mandate of the learned arbitrator. Millets, is that para 3? Yes. Then Millets, if I may kindly take your lordship straight away to para 21.
Yes.
The main controversy that arises for consideration in the present application is whether the petition, as filed earlier and subsequently withdrawn by the petitioner, is at all maintainable in this court, or the power to extend the mandate of the arbitrator lies with the civil court of original jurisdiction in terms of the definition of the term court in section 2(1)(e) of the Act.
Yes.
So, Millets, here it is clearly decided, Millets, it's not, Millets, relating to the Delhi High Court having original jurisdiction. So, Millets, para 22 may I read. Section 11(5) and 6. May I continue, Millets? 11(5) and 6 of the Act relate to appointment of arbitrators by the High Court or the Supreme Court, as the case may be, and details the procedure to do so therein. In case of international commercial arbitration, the power of appointment is vested only with the Supreme Court, while in other arbitrations, High Court has the power to make appointment in terms of subsections 5 or 6 of the Act. Well, as I'm just drawing, there's several judgments, well, I'm just drawing the lordships to the relevant paras. Well, para 25. Section 29A of the Act incorporates an important provision by way of subsection 6. So, 29A6 is referred to, and which, in my opinion, is relevant for deciding the controversy in the present case. The provision confers on a court a significant power of substituting one or all of the arbitrators while extending the mandate under subsection 4. If the need arises and in case such substitution is made by the court, the arbitral proceedings shall continue from the stage already reached and on the basis of evidence or material already collected. Therefore, when it comes to the time limits for passing the award or the extension award of mandate, the section is a complete code in itself. Para 27. If the definition of the court is looked into, no doubt the contention of the respondent seems plausible that the power to extend the mandate of the arbitrator would lie with the principal civil court. However, on a careful analysis, in my opinion, this interpretation would lead to complications and would perhaps be in the teeth of the powers of the courts under Section 11 of the Act. Thus, the question that poses a challenge is whether the term court can be interpreted differently in the context of Section 29A. Plus, the context argument is taken. In my view, subsection 1 of 2 of the Act itself gives that answer, as it begins with the expression in this part unless the context otherwise requires. Thereafter, para 28, if I may read, power to extend the mandate of an arbitrator under Section 29A4 beyond the period of 12 months and further extended period of 6 months only lies with the court. This power can be exercised either before the period has expired or even after the period is over. Neither the arbitrator can grant this extension and nor can the parties by their mutual consent extend the period beyond 18 months. Till this point, interpreting the term court to mean the principal civil court as defined in 2(1)(e) would, to my mind, pose no difficulty. The complexity, however, arises by virtue of the power of the court to substitute the arbitrator while extending the mandate. And this complication is of a higher degree if the arbitrator has been appointed by the High Court or the Supreme Court. Coupled with this, one cannot lose sight of the fact that the legislature in its wisdom has conferred the powers of appointment of an arbitrator only on the High Court or the Supreme Court, depending on the nature of arbitration and as and when the power is invoked by either of the parties. There may be many cases in which, while extending the mandate of the arbitrators, the court may be of the view that for some valid reason the arbitrators are required to be substituted, in which case the court may exercise the power and appoint a substituted arbitrator and extend the mandate. In case a petition, para 29,
Yes.
in case a petition under 29A of the Act is filed before the principal civil court for extension of mandate and the occasion for substitution arises, then the principal civil court will be called upon to exercise the power of substituting the arbitrator. In a given case, the arbitrator being substituted could be an arbitrator who had been appointed by the Supreme Court or the High Court. This would lead to a situation where a conflict would arise between the power of superior courts to appoint arbitrators under Section 11 of the Act and those of the civil court to substitute those arbitrators under Section 29A of the Act. This would be clearly in the teeth of the provisions of Section 11 of the Act, which confers the power of appointment of arbitrators only on the High Court or the Supreme Court, as the case may be. The only way, therefore, this conflict can be resolved or is reconciled, in my opinion, will be by interpreting the term court in the context of Section 29A of the Act. To be a court which has the power to appoint an arbitrator under Section 11 of the Act. Plus the para 35, ultimately, for the reasons stated over, the application is allowed. So here the Delhi High Court exercise the jurisdiction under the 29A to extend the limitation, read with Section 11, extend the time period. Similarly, there are the judgment of Kerala High Court, if I may kindly, which has original, doesn't have original jurisdiction. I'm sorry. There are different courts. Kerala High Court, Gujarat High Court, Patna High Court, Calcutta, Madhya Pradesh, Bombay, and Allahabad. In this case of Lot Shipping Company Limited versus Cochin Port Trust, AIR 2020 Kerala 169. May I take your lordships to para 1. A learned judge of this court has referred the above case on the opinion that it requires an authoritative pronouncement by a division bench on the issue with respect to interpretation of the word court contained in subsection 4 of 29A of the Arbitration Act as it stood amended, which came into force on such and such. Para 4. While considering the question, this is this division bench of Kerala High Court refers to a single judge bench of Kerala High Court, which had decided the contrary. And that has been overturned in this judgment, para 4. While considering the question as to which is the court specified under subsection 4 of 29A, a learned judge of this court in the decision in Messrs. URC Construction Private Limited such and such held that going by subclause 1 of clause E of subsection 1 of 2, that is 2(1)(e), in the case of domestic arbitration, an application under subsection 29, subsection 5 of 29A, seeking extension of the period referred to in subsection 4, has to be made before the principal civil court of original jurisdiction in the district or the High Court in exercise of its original jurisdiction. This is what the Honorable Single Judge had decided.
Yes.
May I take your lordships to para 9?
Yes.
Question to be decided is whether the term court contained in 29A4 requires a contextual interpretation apart from the meaning contained in 2(1)(e) of the Act. A contextual interpretation is clearly permissible in view of the rider contained in subsection 1 of subsection 2, that is, unless the context otherwise requires. Well, ultimately,
All right, we will see this decision. Oh, I'll see other.
Yes,
other decision.
Gujarat High Court.
Gujarat has been referred to in Delhi.
Yes, that Nilesh Patel judgment, your lordships. I have that judgment. That also lays down the same law. Then Patna High Court.
That must be division bench.
There's one division bench and one by the Honorable Chief Justice. India Power. This is by the Honorable Chief Justice. India Power Corporation Bodhgaya Limited versus South Bihar Power Distribution Company Limited. There is only a Manu citation. I couldn't refer to the equivalent site. I couldn't find the equivalent citation. May I take your lordship straight away to para 6? The question, I'm sorry,
please.
The question that arises in the above case are number 3, the third question. Whether the Chief Justice or his designate empowered under Section 11 to consider a request for arbitration can grant extension of time as required under Section 29A of the Act of 1996, or is it the principal civil court of original jurisdiction in the district or the High Court having original civil jurisdiction alone who will be empowered to exercise the power under Section 29A of the Act? Now, para 21, if your lordships. Some of the arguments, just touching upon that. 21. The further question that arises is on the sustainability of a proceeding under 29A before the Chief Justice, or whether it has to be initiated before the principal civil court of original jurisdiction, which is the district court. 22. I have to immediately notice that the definition clause of Section 2 of the Act commences with the words, in this part unless the context otherwise requires.
Yes.
It is in the context of Section 29A read with Section 11 that the word court employed in Section 29A has to be interpreted. Then Amit Kumar Gupta, the Calcutta High Court, that also I have. Amit Kumar Gupta has been referred to. If I may kindly take your lordships to only para, the quoted para 18. Under para 22, the quoted para of Amit Gupta. In my view, may I read please?
Yes.
In my view, the word court used in Section 29A partakes the character of the appointing authority as has been prescribed in Section 11 of the Act, as the court exercising jurisdiction under Section 29A of the Act may be required to substitute the arbitrator in a given case. Such right of substituting can be exercised by a court which has the power to appoint. The power to appoint has been prescribed in Section 11. Therefore, the power to substitute should be read in the context of the power of appointment under Section 11. Then Delhi High Court, that first judgment that I showed, that has also been referred at para 23. Then that Gujarat High Court judgment, And ultimately, let's para 26 that Kerala High Court judgment, which I division bench judgment, then Allahabad High Court judgment has been referred.
Yes.
Then at para 28, another judgment of Patna High Court has been referred to, which is a division bench judgment, which I'll just hand over to your lordships. Let's wait. Yes. There, para yes, para 28. Now, what is quoted? I'm just reading that. 86 of that division bench judgment is quoted. The division bench holds. Now, a piquant situation arises if the power to appoint arbitrator has been vested with High Court and Supreme Court under Section 11(4) of the Act. Legislature would never intended its substitution under Section 29A(6) by the Court of Principal Civil Judge, as it appears from the plain reading of 2(1). But the meaning of court for the purpose of 29A would be different from what it is under Section 34 or 37 of the Act. In the present case, though the arbitrator was appointed by the parties themselves, but in case of any dispute, they would otherwise have been appointed by the High Court or the Supreme Court, as the case may be. And taking cue from this provision under Section 11(4), 5, and 6, we can say that if the principal civil court cannot substitute the arbitrators by corollary, it cannot extend the period of arbitrators under Section 29A(4). Otherwise, it would give rise to conflict between the power of the High Court as well as the Supreme Court to appoint arbitrators under Section 11 and those of the principal civil courts to substitute those arbitrators under Section 29A(6). Ultimately, at para 30, it is concluded, hence I find that the jurisdiction to extend the period of time has to be exercised by this court under Section 29A. There shall hence be an extension of the mandate of the arbitral tribunal by 4 months, such as. Then
Yes.
MP High Court and
Who is for the other side? You are
I'm for the other side.
You don't have any objection?
No, we don't have.
Yes. Any other decision?
That Calcutta High Court, this is the division bench judgment of Patna High Court.
That is very honorable Mr. Justice Arun Kumar Jha.
Yes, I am so great.
Yes.
Justice Jha.
Yes.
Plus the relevant
Anything?
paragraphs I have underlined in that. And also Rajesh Kali, this is Amit Gupta, the Calcutta High Court judgment decides the same issue which has been referred to all these things. I'll just, I'll not place it.
So let there be a judgment of Odisha High Court also.
As your lordship pleases. Then this is MP High Court, which also doesn't have original jurisdiction, by Justice Dharmadhikari, single judge bench.
Yes.
MP High Court, what I've done, in those judgments, your lordship must have seen there's an underline which I've done, and those Rajesh Kalia. There also, the same issue has been decided that what essentially transpires is that since it is your lordships who have appointed the arbitrator.
No, that is different. Had that expression been not there in Section 2, it would have been difficult for this court to logically, based on logic, decide that. It is only because of that expression that unless the context otherwise
precise.
So that gives the court some scope of interpretation. Otherwise, we are bound by what the law says.
In fact, all these judgments will have relied upon that phrase.
That is the only thing.
So let's say 2(1)(e) is not an all-encompassing definition of the court. It is contextual in nature. The Bombay High Court and Allahabad High Court judgments also I have. If your lordship needs, I'll give it, or else.
Yeah, I'll just incorporate them.
Malus.
Learned counsel for the petitioner and learned counsel representing the respondent. List this matter on Friday.
For orders. Friday for orders. Minus. Oblations. Not this Friday, next Friday. Very good. This only thing, your lordship may kindly keep in mind, 6 months is what. Already. The arguments are going on. Great.
Item number 5.
Please, your lordship. In item number 5 and find an IA for recall/modification of the order passed by this honorable court on 12/5/2023, your lordship, wherein a nominee on the side of the petitioner was appointed. Subsequently, a nominee on the side of the respondent has also been appointed, but the umpire has not been appointed till yet, and the arbitration proceedings are still to be initiated. Hence, to re-agitate the matter and for appointment of arbitration by this honorable court, I filed that application, your lordship.
Yes, this order was passed in 2023. What happened thereafter?
Thereafter, your lordship, if the documents provided in IA number 2022 of 2023 may be seen, especially the Annexure 2 series, wide mail dated
IA number?
IA number 22 of 2023.
Yes.
Annexure 2 series, which starts from page 9, your lordship. By the mail dated 12 June 2023, a nominee was appointed, nominee of arbitrator was appointed from the side of the respondent, your lordship. It is named Amit Jamshedkar. And the nominee arbitrator from the side of the petitioner is my learned senior Saktidhar Das, designated senior. But your lordship, upon multiple trials, an umpire arbitrator was not able to be decided upon.
Then
Your lordship, in the meantime, the respondents appeared the Honorable Supreme Court, challenging the order passed by the Honorable bench of this court with regards to the appointment, that is the 12/5/2023 order. That said, SLP has been dismissed on that is given in Annexure 3, your lordship. Subsequently, till now, there is no consensus with regards to appointment of the third arbitrator. And the arbitration proceeding is yet to be initiated.
So what is to be done? Let me see the arbitration clause first.
Yes, your lordship. In the arbitration petition, your lordship, is page 14, Annexure 1. Clause 8 is the arbitration clause.
Where is the arbitration petition? Why not?
ARBP 9 of 2020.
So what is that? Please read.
The clause is, your lordship, if any disputes, controversies, differences arises between the parties hereto of or in relation to this agreement or any breach thereof
shall be finally settled by arbitration by two arbitrators, one to be appointed by each party to the dispute, and the arbitrators shall, before taking upon themselves the burden of reference, appoint and umpire it at Bhubaneswar as per the Arbitration and Conciliation Act of 1996. The award given by the arbitrators or umpire, as the case may be, shall be final and binding on the parties.
Then
Till date, your lordship, my grievance is that the umpire has not been decided.
what should the court do?
I filed an IA for recall or modification, your lordship. If your lordship may be pleased to appoint a sole arbitrator to decide the matter.
Sole arbitrator cannot be appointed.
Yes, your lordship, given the clauses of the agreement, your lordship. A timeline was fixed by the order dated 12/5/2023. That timeline also may, if may be extended and a strict timeline may be given by this honorable court, then also, your lordship, the grievances of the petitioners will be sorted out, your lordship.
My lords, it is also to be humbly submitted that the IA was served on us on last Thursday, on 22nd of February. So we would like to file a counter to it because there are certain allegations raised against us, which we would like to file a counter.
Your lordship, if my learned counsel is suggesting that at least an advance copy may be served before the date which is fixed for hearing of the matter.
Did you serve upon her the advance copy?
I've already served the copy of the IA. Vice President.
Why has this happened? Why umpire could not be selected?
My lords, we had actually filed the SLP, and after that we had some problem in regard to it because we were waiting for the SLP to be dismissed and whatever the honorable court would have directed. But then after that, there was no.
I may be permitted, your lordship, the SLP has been dismissed since 29/8/2023.
So this is what the court is asking from you also, that why?
There are on multiple occasions, there are efforts from the side of the petitioner so as to arrive at a consensus. But time and again, the respondents, they're trying to avoid to start the arbitration proceeding.
My lords, may kindly grant us a few weeks' time, we'll find counter.
2 weeks time is allowed for the respondent.
Responding, yes, my lords.
Respondent to reply to IA number so and so 22.
Yes, your lordship. 22.
22 of 2023. Unless this case on 2 weeks.
Item number 6.
Much obliged, my
Much obliged. Item number 6, your lordship. As per the noting, I have to take fresh steps in the matter. The notice is unserved.
Item 7.
Much obliged.
Item 7 of notice was sent. I just not absent. I will take fresh steps.
Item number 8.
And item 8, my lord, I am appearing to the petitioner. In the last occasion, there was no appearance on behalf of the opposite party, and they have not also filed any counter.
Well, I am appealing for the opposite party. Since it is a China company, my lord, I lost all contact with them after the COVID-19 breakup. So my prayer is that let the case notice go to them.
Correct and present address. I'll file reports within a week, ma'am.
Item 9.
May I please lawfully. My lordship, we have filed a 11-6 application for the appointment of the arbitrator, my lordship. We have filed a 11-6 application for the appointment of the arbitrator. And my lordship, can you have a glance to the page number 39, where there is an arbitration clause. In clause, page number 39. In the event of any dispute in the matter, the same shall be referred for arbitration to the nominee appointed by MD Moffat. The decision of the arbitrator shall be final and binding on both the parties.
Page 39.
Yes, my lordship, in my petition. Annexure 5, my lordship.
So who is MD Markfed?
Yes,
No, I'm appearing for the opposite party number 1. But in this case, not pursuant to a section 21 application filed by the petitioner, an arbitrator has been already appointed. And my lords, if your lordship would kindly turn to my lords page 40 of annexure 6 and come to page 43, my lord. Lordship got it? This is an application sent to us by the petitioner company, my lords. Annexure 6, page 40 at page 43, my lords.
Yes.
3 lines from the top, my lords. Hence, finding no other way, as per the terms of the letter dated 8/7/2019, clause 9, which my learned friend is referring to, the present notice is being issued under section 21 of the Arbitration and Conciliation Act for commencement of arbitration proceeding for resolution of such dispute. Pursuant to this, my lords, we have already, my lord, appointed an arbitrator, my lords, and that your lordship would get it, my lords, at annexure 10 at page 52, my lords. Honorable Justice B.C. Gupta, ex-additional district and session judge, has been appointed as arbitrator, my lord, annexure 10 at page 52. And a notice, lordship got it?
To
Page
that, my
52.
lordship, on page 54, annexure 11, we have.
Yes, Page 52, we have already appointed that arbitrator. Arbitrator, my lord, at page 53, has given a notice, my lords, to the present petitioner to appear before him. They do not appear, my lord, at page 54, annexure 11. Lordship's at page 52, my lords.
Yes.
Page 52, Honorable Justice B.C. Gupta, my lords.
He is retired.
He is a retired additional district judge. Your lordship would get his name at serial number 3, my lords, as a footnote, my lords. Sri B.C. Gupta, additional district and session judge, retired. Page 52, my lords.
Yes.
Thereafter, the learned arbitrator at page 53 writes to the present petitioner, my lords, that he has been appointed and he fixes the time on 8/7/2022 in Markford House, Chandigarh, my lords. Then, my lords, the petitioner responds to the arbitrator at page 54, my lords, annexure 11. And they say that they have initiated an arbitration proceeding at Bhubaneswar. And since they have moved this honorable court, my lords, so he should stay his hands. They write to the arbitrator, my lords, that he should stay his hands because since the cause of action arises at Bhubaneswar, he doesn't have the jurisdiction. My humble contention, my lords, is on their request under section 21, we have appointed an arbitrator, and as per the Arbitration Act, my lord, the arbitration proceeding has commenced. So if they have a problem with the arbitrator, my lord, they can raise these questions before the arbitrator himself. Instead of doing that, first they file a section 9 application, my lords, at Bhubaneswar Commercial Court, my lords. That stands to be dismissed. Then they file a section 11 application before your lordship's court, my lords.
No, my
So your lordship would see, my lords, your
No, my
lordship would see
lordship,
let me just complete. Let me just complete. If your lordship would see, my lords, they have annexed it at annexure 7, page 44. Your lordship would see the petitioner's name, my lords. Mrs. So and so Advent Group Company, second floor, Mohali. And Mohali, my lord, is the place where
We are reading 44.
Page 44, my lords. This is an application, there's an order sheet which my learned friend has annexed in a section 9 application, my lords. The petitioner, your lordship, may kindly see the description. Mrs. So and so Advent Group of Companies, so and so, Mohali, so and so. So, my lords, if I may place the entire matter, my lords, your lordship would appreciate that Markfed, for the Rabi season, my lord, they had floated a tender, my lords, for purchase of urea, my lord, what fertilizers. That your lordship would get it at Annexure 1, my lord. Sequentially, if your lordship would go, my lord, that will be easier for my learned friend also to respond. Page 13, if your lordship would kindly turn, my lords.
So, but according to you, you appointed an arbitrator.
My lords.
According to her, arbitrator has not been appointed.
Not, it is their own document, my lords, which I am placing before your lordships.
No, ma'am.
They have written to the arbitrator saying at all points of time that you do not have the jurisdiction. My humble contention, my lord, is since the arbitrator has already been appointed, if you have a problem with the arbitrator, section 12 is all there, my lords. Section 13 is there, my lords. Section 16 is also there, my lords.
Let me hear.
Yes, my lordship. My lordship, what happened? We have given them a section 21 notice. To reply to that, they have sent us a reply to the section 21 notice, but they have not mentioned any name of the arbitrator. Right, section 11 says that if both section 11 appointment of the arbitrators, a person of any nationality may be an arbitrator unless otherwise agreed by the parties. But without our consent, directly learned BC Gupta.
So you are referring to which
Section
clause?
11, my lordship. Section 11 says that if both the parties agree, then with both the consent of the parties, they can finalize the arbitrator.
No, but that was not your agreement.
Yes, my lordship. That is my lordship.
That is
What happened? What
Page
happened?
39, your lordship may kindly see.
That is not the agreement.
My lordship, what happened? We have filed section 9 application. Section 9 was admitted and issued notice to the opposite parties. And where the section 9 dismissed, my lordship, kindly have a glance to the order of section 9. Because of 11.6, we have filed 11.6 here. They said that there is then Justice, Honorable Justice High Court will decide regarding the jurisdiction. That's why they have dismissed my section 9 petition. And regarding the jurisdiction, not a single word they have in the order they have Learned Commercial Court has put, my lordship. That's why I come before this before your lordship regarding the jurisdiction and regarding the unilateral appointment of the arbitrator. Because without giving us a notice, they have finalized the arbitrator, and the arbitrator is sending us a notice, my lordship. The notice they are referring, my
Then
lordship.
why are you referring to this 11.1? 11.1 is nothing.
No, my lordship, not 11.1, my lordship. Section 11 says that if agreed, both the parties agreed, then they can finalize the arbitrator. In 6 also, my lordship, kindly have a glance to the 6, my lordship. Where under an appointment procedure agreed upon by the parties, a party fails to act as required under the procedure, the party fails to act as required under the procedure. They have not sent us any name that this person we are going to finalize as the arbitrator.
Madam, see, this says where under an appointment procedure agreed upon. So there was an appointment procedure agreed upon.
Yes, my lordship.
You are relying on that clause.
Yes, my lordship.
Clause 9 or something.
Yes, my lordship. MD Marford was to appoint an arbitrator.
Yes.
But they have to follow the procedure, my lordship.
What is the procedure?
They have to give us a notice that this person we are finaling the arbitrator. If both the parties agreed, then the arbitrator can be finalized.
Where is that?
It is, my lordship, in 11, my lordship, 11.6, my lordship. In section 11.6 of section 6, my lordship.
Yes.
Where under an appointment procedure agreed upon by the parties, a party fails to act as a required under the procedure. That procedure, I am saying that, my lordship, they have to give us a notice.
Where is that procedure that you should be given a notice?
My lordship, B says that the parties or the two appointment are my lordship, can you have a glance to section 11.8?
You could have argued, probably subject to that there could not have been such arbitration agreement that one party shall have the liberty to appoint an arbitrator. How can you have such arbitration?
They have, my lord, they have agreed to it. What all I'm
Even
trying,
if they had agreed to that.
my humble contention, my lord, is this honorable court, my lords, when the entire Mohali proceeding was being initiated, the agreement was at Mohali. The entire cause of action is at Mohali, my lords. The petitioner's branch office at Mohali, my lord.
The question here is that there is an arbitration clause
My lords,
which provides that you can appoint an
my
arbitrator.
lords, my lords,
You are a party.
my lords.
You have the authority under that arbitration agreement to appoint
My lords,
anyone.
my lords.
How that can be done?
Look, my humble contention, if my learned sister has an objection to that, my lord, that, my lord, she has to approach any court in the state of Punjab, my lords, not in Odisha. Because your lordship would appreciate the person, my lord, who have participated in the agreement, if your lordship would kindly turn to page.
No, the agreement had taken place where?
Mohali, my lords, Punjab.
It's
Your
a
lordship may-
tender, my lord.
Your lordship, it's a tender, it's a e-tender. Your lordship may kindly turn to Annex 1. Annex 1 at page 13, my lords. Page 13, Annex 1. Lordship, page.
Yes.
Serial number 18 is the other concern of the present petitioner. Zuhari Agrotech, so-and-so, second floor, Mohali.
Yes.
Lordship got it? So they are the persons, my lord, who had participated in this e-auction. And all this, my lords, and your lordship would kindly turn to Annex 2, page 15.
Yes.
Lords, here, my lords, we have said that the also regional manager, Advent Paradip Port Phosphates, so-and-so, Mohali. Your lordship get it? The third letter regarding supply of DAPB for Rabi 2019-2020, just about that, notes. Regional manager so-and-so at Mohali. Lordship got it, notes?
Page number 15.
Page number 15, notes, 1-5. The third name, notes, the regional manager.
MS.
Just about the subject.
Yes.
It's your lordship would see Mohali.
Yes.
Then, my lords, page 16 also, again, my lords, serial number 18, Mohali.
My lordship, can
Please,
you
just
Let him complete. Arbitration.
Page 16, your lordship would again see Mohali. Then, my lords, again, my lords, at the cost of repetition, page 17, serial number 18, Mohali. Page 18, my lords, again, Mohali. And your lordship would see, similarly, at all points of time, it is Mohali. And this particular, my lord, and then they give, my lords, notice, address, my lords, to the secretary at page 22, Secretary Cooperation, Government of Punjab. Your lordship may kindly see, my lords. Page 23. Sorry, 22. At page 23.
Yes.
Second paragraph. Our regional office, Chandigarh, write their letters number so-and-so, 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 2020, and our vice president sales and so-and-so has repeatedly requested Markford so-and-so. So it's the entire negotiation is at Chandigarh with the petitioner's unit at Mohali, Manoj. Then if your lordship would just skip over the item, let's skip over the pages, then your lordship will kindly come to Millard's annexure 5 at page 38. 38 notes. This is our letter to them, and they accept this. The regional manager, Advent Group, so-and-so, second floor, Mohali. Lordship got it?
Yes.
Then, Millards, which my learned sister, Millard, is referring to, which has an arbitration clause. We are referring to that arbitration clause at page 39. This is addressed to Mohali, regional manager, Mohali. Then, your lordship will kindly turn to annexure 6. The legal notices they give, my lord. Your lordship may kindly see the profile of the client, my lord. Annexure 6 at page 40. Lordship got it?
Yes.
Your lordship sees this is the legal notice sent by my learned sister's client, my lord. The client's profile. Advent Group, so and so, second floor, face Mohali. Then your lordship, after this, my lords, your lordship may see the section 9 application, the description of the petitioner. So and so Mohali. They are the petitioners in the section 9 application at Bhubaneswar. So, my lords, the entire, my lord, they file, give a notice, my lord, they enter into an agreement at Mohali. They give an application, file an application under 29 for appointment of an arbitrator under 21, my lords. We appoint an arbitrator and they rely on clause 9. And clause 9 says that the MD will appoint. And if they have any grievance regarding this arbitration clause or the arbitrator, my lords, in my very humble submission, my lords, this honorable court may not have the jurisdiction to entertain this section 11 application.
My lordship, kindly have a glance to from page 20, my lordship. All the because it is a monetary dispute and all we have sent a notice from our head office of Bhubaneswar, my lordship. All the communication has been sent from the Bhubaneswar.
That may not create cause of action.
Because my lordship.
You can take a plea, whatever
my
you are
lordship
taking before the arbitrator. Arbitrator will decide.
We have denied through the arbitrator, my lordship. When the arbitrator sent us a notice, my lordship, we have denied to the arbitrator regarding the jurisdiction, my lordship. Can you?
So you let him decide. If he does anything, you can challenge that. This application has been filed for appointment of an arbitrator under section 11, Directive 6 of the Arbitration and Conciliation Act 1996. The arbitration. Where is that?
Arbitration clause, my lords, is at page 39.
Page 39.
Clause 9.
The arbitration clause 9 of a communication dated 8/7/2019 is the bracketed annexure 5. Annexure 5.
Annexure 5
is the arbitration clause which reads as under the top. It is next. It is specific stand of the respondent that an arbitrator has been appointed. So it has also been argued that since no cause of action has arisen within the territorial jurisdiction of this court, the petitioner ought not to have filed the present application before this court. Stop next. The counsel appearing on behalf of the petitioner, on the other hand, has submitted that several communications have been made by the Bhubaneswar office of the petitioner, and therefore this court has jurisdiction. The SOPSI has also submitted that the arbitrator said to have been appointed by the respondent does not have the jurisdiction to entertain the arbitration, the dispute in the arbitration proceeding. Stop. Next. It is evident from the rival submissions made on behalf of the parties that the petitioner is questioning the competence of the arbitrator appointed by the petitioner respondent to resolve the dispute through the process of arbitration. Stop. If according to the petitioner, comma, the arbitrator does not have the jurisdiction or otherwise not competent, comma, the petitioner shall have liberty to raise a question before the arbitrator himself. Stop. This application stands disposed of with the observation as well.
Interim orders to stand vacated.
Interim order stands vacated.
And your lordship will see the petitioner is also Mohali. Petitioner in this writ application is Mohali, my lords.
But
Why it has been filed in Bhubaneswar?
And that was been.
Quick one.
Sorry, in Odisha, why the case has been filed in
Learned sister can explain.
No, because she's here.
She's the legal notice of her, my lord.
Whatever.
It's a pleasure, my lords. A pleasure.
Item number 10.
May I please, your lordship?
Number 10 blocks.
My lord, the matter relates to appointment of arbitrator.
Item number 10, your lordship. I'm for open number 2, your lordship. Your lordship, I'm seeking for 2 weeks of adjournment as we are working to resolve the issue.
My lord, my friends have taken several adjournments. Let it be the last one.
That's me, your lordship.
Then counsel appearing on behalf of the respondent state that the adjournment and that the matter may be adjourned for 2 weeks as the parties are making attempts to resolve the dispute. Stop. Then counsel for the petitioner has submitted that on the same very ground, several adjournments have been taken. Stop. By way of last indulgence, the matter is adjourned till next date.
Item number 11.
I humbly pray Miller for appointment of arbitrator under section 11 of the Arbitration Conciliation Act, since there is agreement executed between the parties to the contract and the arbitration agreement is there and the clause is found place at my last.
Sir, just a minute.
My lord.
Which item is this?
11 Miller.
Just a minute, sir. Take a look. Just a minute. Just a minute, Mr. Sir.
11.
Yes, what do you want?
Miller. My prayer before Miller for appointment of arbitrator for adjudication of the dispute between the parties to the contract, since the agreement was executed between the parties and there is an arbitration clause which is found place at page 29 of my lord's brief, whereby arbitration clause is stipulated at page 29.
Just a minute. Page 29.
My lord, towards just beginning, towards top, settlement of dispute under clause 23.1, thereafter arbitration clause which is found place under clause 23.2 Miller.
Clause
23.2 Miller.
Page 29.
Page 29 Miller, my lord's brief.
Contractor, where is that? It is not clear. 29.
23.2 Miller.
23.2, it is not clear. All right. If the contractor is dissatisfied with the decision of the employer, the contractor within a period of 30 days from the receipt of may refer the dispute to
arbitration. So before going
for
to the
arbitration. Yes.
I humbly invite attention of your lordship with respect to dispute settlement clause. If the dispute arose between the parties, then it is upon to the contractor to make a reference for the engineer's decision. So the contractor made a representation before the engineer for his decision under Annex 18.
Yes.
At page 59.
Yes.
Thereafter, since the engineer failed to give his decision, he had approached the chief engineer, who is employer, who is power delegated to him, make appeal and to give his decision with respect to settlement of dispute. So the chief engineer also failed, as per Annex 19. Thereafter, the petitioner served notice for hearing of the appeal, but the chief engineer, who is supposed to empower the power to decide the dispute, but he failed to decide. Thereafter, my lord, the petitioner came up before your lordship with a prayer for appointment of arbitrator. So
I am ready to appoint. Who is to be appointed?
Here, the state is the opposite party here. We have filed our objection. Our objection is that the issues that those have been raised, those are non-arbitrable as per the scope of the agreement. If I may read the settlement of dispute clause 23.1, if I may read. If the contractor considers any work demanded of him to be outside the scope of the contract, or considers any drawing, record, or ruling of the engineer in charge on any matter in connection with or arising out of the contract of the carrying out or work to be unacceptable, he shall promptly ask the engineer in chief in writing for written instruction or decision. Thereupon, the engineer in chief shall give his written instruction or decision. The contractor shall promptly proceed without delay to comply with such instruction or decision. If the engineer in chief fails to give his instruction or decision in writing within a period of 30 days after being requested, or if the contractor is dissatisfied with the instruction or decision of the engineer in chief, the contractor may within 30 days after receiving instruction or decision of the engineer in chief appeal to the employer, who shall afford an opportunity to the contractor to be heard and to offer evidence in support of his appeal. The employer shall give his decision within a period of 30 days after the contractor has given the said evidence in support of his appeal. 23.2. If the contractor is dissatisfied with the decision of the employer, the contractor within a period of 30 days from the receipt of the decision of the employer may refer the dispute for arbitration. Now, what 23.1 says, it's a qualified, so they have qualified the disputes, meaning that it says that if the contractor considers any work demanded of him to be outside the scope of the contract, or if he has any issues with regard to the drawings, record, or ruling of the engineer in charge. Now, my lords, here the arbitration notice, if I may request my lords to turn to Annex 22, which is at page 140. What is the dispute of the contractor here, the petitioner here? Page 114 is his arbitration notice. My lords may turn to page 124 with an internal page of 11. The dispute is towards dues towards price escalation and interest. Well, it's dues towards price escalation and interest thereof, millards, are not millards covered under 23.1. 23.1 is clear. So therefore, it would come under something which is under the accepted matters or non-arbitrable matters. In other words, this honorable court under 11.6 has the power to, at the preliminary, at the stage of section 11, do a preliminary inquiry whether the disputes which have been raised are arbitrable or not under the scope of the contract. And these disputes clearly fall outside the scope of 23.1. And therefore, the remedy does not lie before the arbitral tribunal, but in a civil court of law.
So read it again.
Please.
If the contractor considers any work demanded of him to be outside the scope of the contract,
or considers any drawing, record, or ruling of the engineer in charge on any matter in connection with or arising out of the contract.
The ruling of the engineer in charge is not under challenge.
Please, Milord.
Not in dispute.
Please, Milords. The ruling of the engineer in chief is not under challenge.
No, they are not under dispute. There is no question of any challenge.
Please, my lords.
Is there any ruling of the engineer in charge?
Well, the engineer in charge as well as the superintendent engineer, my lords, if I may turn my lords to, so the contractor had raised an issue with regard to price escalation.
Sir, see, even on the point of price escalation,
Please, my lords.
is there any ruling of the engineer in charge?
My lords, there is no ruling of the engineer in charge. But at the same time, my lords, the ruling of the engineer in charge is required, my lords, under 23(1) only in certain issues which have been, my lords, laid out here.
No. Please read it.
Please, my lords. If the contractor considers any work demanded of him to be outside the scope of the contract, or considers any drawing, record, or ruling of the engineer in charge on any matter in connection with or arising out of the contract of the carrying out of the work to be unacceptable.
Unacceptable.
Please, my lords.
If any of these things are unacceptable, the matter will have to be referred to arbitrator.
My lords, here, my lords, the issue is, my lords, of price escalation, my lords, which are dues, my lords, which he's claiming. He's claiming dues, my lords.
All right, the matter has to be referred to arbitrator. That's the only question. Tell us, suggest us any name. Suggest any name.
Was Justice S.K. Mishra, retired Chief Justice of the Jharkhand High Court. Yes, my lord.
And Lawrence Print is suggesting Justice S.K. Mishra, retired Chief Justice of the Honorable Jharkhand High Court. I don't have any objection with that.
All right. This application has been filed under section 11(6) of the Arbitration and Conciliation Act 1996 for appointment of an arbitrator for a resolution of the dispute between the contractor, bracketed the petitioner, and the employer, bracketed the state of Odisha. So, the arbitration clause, the settlement of disputes clause reads thus 23.1. So, 23.2 of the sin agreement reads as under. Stop. Next, an attempt has been made on behalf of the state that since dispute in the present matter relates to escalation of price, the such dispute is not arbitrable in terms of clause 23.1 of the agreement. Stop. In my view, however, it is the case of the petitioner that he had approached the engineer in charge for his decision on the point of price escalation. So stop. The engineer's decision is against the petitioner. So stop. He had preferred an appeal also to the employer, but till date, no decision has been taken. So he accordingly submits that since the decision of the engineer in charge is not acceptable to the petitioner, this application for appointment of arbitrator is maintainable. Stop. After having
gone through the terms of agreement as noted above, I find substance in the stand taken on behalf of the petitioner. First off, accordingly, with the learned counsel for the state as well as learned counsel for the petitioner have recommended name of Mr. Justice S.K. Misra. So and so. Yes.
Item number 12.
My lord, let it be the last adjournment. They have taken a lot of adjournments in the last year.
Last year.
Last year, my lord, this case has been listed a lot of times and they've taken adjournment. Let it be the last one. then.
Is for whom?
I'm for the opposite party, he's for the, on behalf of the petition.
You are for the petitioner. Then you want the arbitrator to be appointed. Why are you seeking adjournment? Huh?
My lord, there are all. It's not a brief, my lord. He is taking an adjournment on behalf of the senior, my lord.
Why every time you are seeking adjournment? I'm curious to know
My lord, recently.
that it is your case. You want an arbitrator to be appointed. You filed your application in 2023. In 2020, till 2024, our arbitrator has not been appointed and you are again seeking adjournment.
Even last chance.
As by way of last indulgence, the request of learned counsel for the petitioner, the matter is adjourned till yes, set in 2 weeks. 13.
My mother, senior counsel is on his legs. To take up this one.
So do the senior counsel here leave the court after in the second half on Fridays? In every matter, all that as requested on behalf of the respondent.
Opposite party.
Opposite party number 2 lists this matter on 2 weeks.
15th minutes. 15th. I'm for the petitioner.
15. 2 weeks means yes. 15.
Item 14 is the last chance, because pleadings are complete. The counter, the general, everything has been filed.
I'll say.
Item 14. Obliged. Same matters.
14.
Item 16.
I am filing this question for appointment of arbitrator. Notice has already been sent, but they have not been back as per the noting by the list, my lord. Lordship will then tracking report maybe otherwise investment press notice. Nobody approves.
Press notice. All right.
Item 17.
I am the opposite party in this case. My lord, 2 weeks time, please kindly.
The matter was taken twice.
Conducted advocate
And
out of the state.
on 13th October, you also can announce the last order. Both parties appeared. Yes, both parties. Council appears. They have also taken time, 2 weeks. And you also may grant time for last chance. This matter is 23.
Filing the counter.
Let them file counter, but last chance.
Do you agree that arbitration
Yes,
is required to be appointed?
Last time, sir. Yes. Sir, sleep.
See the honorable to answer.
Senior counsel, conducted counsel.
As requested on behalf of the respondent, by way of last indulgence, the matter is adjourned to 2 weeks.
As a last chance.
Last we have mentioned.
All right.
Item 18.
It- 18, I'm applying for opposite party, apply for 2 weeks time, my lord.
Why?
Pleadings are complete, my lord.
Then,
My
because the pleadings are complete, therefore it should be.
no, my lord, my senior will argue this one.
2 weeks as requested. Yes,
Now, for the petitioner, not sure, fix up a date.
15.
15. Item 19.
Similar, my
Same, lordship.
Item number 20.
Vichy, my lord. I'm on. My lord, I'm on Vichy.
Number 20, I'm appearing for the respondent number 2.
This is an application filed under section 11 for appointment of an arbitrator, my lord. Yeah, the respondent number 2 has already appeared. And even though steps have been taken since 15/9/23, the respondent number 1 has not appeared. However, the arbitration clause, I have mentioned it, Your Honor, may kindly.
No, who is respondent number 1?
So there is this arbitration is arising out of a partnership deed, Your Lordship. There are 3 partners, a petitioner and the opposite partner 1 and 2. I am for the opposite partner number 2. The last partner is opposite partner number 1.
Presence of opposite partner number 1 is required or not?
Yes, sir. It would be necessary, Your Lordship.
Then notice has been served upon him.
Notice has been sent to him on 15/9.
Correct. On the website, it shows since 15/9/2023, notice has been issued. I do not know whether that has been served or not.
So what?
Sorry.
Is appearing. No, no one is appearing. Despite service of notice upon opposite party number 1, there is no representation on his behalf. First off, this matter on 15. When was the notice served?
October 2023.
So we on the next date, no representation is found on behalf of opposite party number 1. The court shall consider passing appropriate orders for appointment of an arbitrator.
Item 21.
Item number 21, Your Lordship, I beg your pardon, I am appearing on VC.
All right.
Your Lordship, this is a matter regarding extension of time under section 29A of the Arbitration Act. Your Lordship, the award is almost ready. The opposite party is also appearing in this matter.
So we are putting up this matter on 15.
Your Lordship may dispose of granting 1 month time, Your Lordship.
This matter will come on 15th.
Yes, sir.
I intend to deliver a judgment on the point as to the jurisdiction of this court to extend
Obliged, Your Lordship.
time. And then orders shall be passed on that day. All right.
As Your Lordship wishes.
15th. Let's this matter on 15th.
Item 22.
May I please, Your Lordship? May I please, Your Lordship?
Please.
In this instant matter, I apologize that I'm appearing virtually. This instant matter is for appointment of an arbitrator. On previous occasion, Lordship, the notice was issued and it has been delivered.
Appointment, please come again.
Appointment, Lordship, this instant matter is for appointment of an arbitrator. On previous occasion, the notice was issued and it has been reflected in the cause list that it has been delivered to the opposite parties. Lordship, I'd humbly pray as such, it is a matter pending since July. I'd humbly pray for appointment of an arbitrator. The clause is in page number 25 of the petition.
Notices served. Notice served. When? At October 23. At October 23. Same order, but only expect service of notice. There is no representation on behalf of the opposite party number. Also opposite party. Opposite party. So, list this matter on 15th. First off, if there is no representation on behalf of the opposite party on the next date also, the court will consider passing appropriate orders for appointment of arbitrator in terms of the arbitration agreement.
Much obliged.
Item number 23.
23, I humbly pray before my Lord. This matter may be called on after a week because the opposite party has not appeared, though endorsement is made in the cause list that AD returned from the sole opposite party after valid service. So I humbly pray, my Lord, if 1 week after the matter may be called on, so that I may take a chance after 1 week, because in his absence, I don't want to make a prayer before your Lordship with respect to appointment of arbitrator.
15.
Special list for orders, item number 1. Item 1.
My excuse, my lord. Item 2, my lordship is passed over. It's urgent or to taken up? Item 2. It has admission.
Special list, item number 1, CRREV1.
Previous list. Previously, there is the item 2 was passed over. Arbitration list. Yeah.
So it is not last of this, it's coming on 15th. also. It's coming on 15th March.
Public.
Special list, item number 1, CRREV 185 of 1998.
Today also there is no representation on behalf of the petitioner. His application is accordingly dismissed for non-prosecution.
Item number 2.
Item number 2, my lord, the case is under section 138 of NI Act. Today I filed the written notes of argument.
I was attached to that chamber of the old office. My name is appears now. In the meantime, one of the friend of that family, that petitioner's family, is practicing here. Today morning, he has intimated that both the petitioner as well as the opposite party expired in the meantime. One of the practicing lawyer is here, in the High Court. He is the family friend of the petitioner. He has said, he told me that it was, as he was then Mr. A.S. Naidu as the advocate, my lord, he has filed the case. I was attached to that chamber. So my name is there. Another name of Mr. S.K. Samal is that now he is the additional government advocate. And another name is S. Mahathi, he is now the judicial member of the district consular. So I have missed the list where my name appears, but I have left that chamber so many years. But the family friend is practicing here. He has intimated in the first hour that both the petitioner as well as the opposite party expired in the meantime. But how far as is true, my lord, I have to ascertain. And
I was
it becomes some other, or my
as amicus curiae by the
direct the state government advocate to inquire through police.
So 138 NI Act, dispute between two private parties. So this cause, even though they died, cause of action will survive if they are substituted because it's a money claim.
My lord, I am on. I will inquire. I will intimate my lord and sister that about the truth of that news.
It is stated at the bar that possibly the petitioners and there are two petitioners.
One petitioner, sole petitioner, or sole opposite.
That the petitioner and opposite party are no more. So stop. List this matter on 15 for learned counsel for the petitioner to seek specific instructions in this regard. Please seek instructions.
I'll introduce.
Item number 3.
May I please, your lordship. But here in this case, luckily the petitioner is surviving, but the opposite party has died. Here, the petitioner is convicted in a private complaint initiated at the instance of opposite party, wherein cognizance has been taken under section 630 of the Company Act.
Yes.
Before going to the other facts, my lord, the basic thing is that there is no proper complaint, legally valid complaint under section 630 of the Company Act.
So what is the conviction?
My conviction is the some fine 500 or imprisonment 500, fine of 500, and in default to go for 1 month of this thing, and directed to deliver position of the quarter. Your lordship,
Conviction under which provision of law?
630 of the Company Act.
Company Act.
Your lordship, kindly see.
Just a minute, sir. Old company.
Should I place it?
No, this is Companies Act 2013.
I think I've got 2 of 2010.
That is the Corona.
The complaint case of is of 94. You also got it, no?
Yes.
And here, if any officer or employee of a company, I am not an officer or employee of the company, wrongfully obtains possession of any property of a company or having any such property in its possession, wrongfully withholds it or knowingly applies it to purposes other than those expressed by the directed or directed in the articles and authorized by this act, he shall on the complaint of the company, or any creditor or contributory thereof, be punished with a fine which may extend to 10,000 rupees. 2. The court trying the offence may also order such offence or the such officer or employee to deliver up or refund within a time to be fixed by the court any such property wrongfully obtained or wrongfully withheld or knowingly misapplied or in default to suffer imprisonment for a term which may extend to 2 years. You'll also kindly see from the LCR, the complaint petition. It is not in consonance with section.
Complaint petition was filed by whom?
Protest by the opposite party.
Who is the opposite party?
Opposite party is an employee. At that time, he was an employee of the company. He is not coming within the scope of the act.
No, which company?
MCL, Mahanadi Coalfield Limited.
The Coalfield Limited is a public.
Yes, company, but the company has not filed. Here, it is that either the company or the creditor or contributor. So none of these people have filed. The magistrate should ought to have proceeded with. The fact of the case is like this. The complaint itself will say that is then on the same basis the entire prosecution fails. Apart from the fact that the opposite party complainant is dead. Because the law doesn't provide.
No, but the complainant is dead. Complainant had not filed the complaint petition in his individual capacity.
And my case is that he has filed it in individual capacity, not by the company or creditor or this thing, as required under section 630 of the Act.
No, but the court is not required to hear the company.
Who?
Company.
Provided company fights it. The court cannot invite anyone to come and say something what you want to say.
Why?
No?
Why? If the petition was filed on behalf of the company.
No, it is not filed on behalf. That is what my submission, the first submission is that it is not in consonance with section 630 means no company has not filed. Company has not filed. First of all, they lost, this opposite party lost an FIR.
Where is the?
So you will also can see the complaint petition, the protest petition.
Where is that?
They maybe there in the LCR, man.
LCR of Canada.
The annexure 1 is the first of all he lost an FIR.
Yes, sir.
The little background of the case is that first of all, before filing the protest petition, he filed an FIR. In the FIR, the police submitted a final report upon inquiry that the land neither belongs to them nor anything and suggested for initiation of proceedings under section 145 CRPC. Thereafter, notice issued to the present opposite party. He was the informant in the case. Then he, in his private capacity, came and filed protest petition, completely, ignoring the allegation made in the FIR. He made another type of allegations in the complaint petition. And he implemented the petition, he has not even implemented the present petitioner. In mechanical manner, the petitioner has been added as an accused. And the magistrate, after inquiry, before going to the provision, without going to the provision under section 630 of the Companies Act, mechanically proceeded and found the petitioner guilty without any materials. I have given the evidence of even the PW, the opposite part number the present opposite party. I have annexed his evidence.
So you were not an employee of the company?
Well,
You were not an employee of the company?
no, I'm employed, probably he was serving there, but he was not allotted the quarter. He was not allotted with the quarter.
That was his case. That was the case of the company.
Your Lordship, can you
That
see
was the case of the company.
Your Lordship, can you see annexure 1?
Please come to section 630.
Yes.
So you said that it does not apply.
No.
Please come.
Yes, ma'am. If any officer or employee of the company wrongfully obtains
Just a
possession-
minute. This condition is fulfilled?
Madam?
This condition is fulfilled that if any officer or employee of a company, so you are an employee of the company.
But that is the basis of the case is not that. I am a trade union leader being an employee of the company at that time. But I have neither obtained permission nor the case of the informant is like that against me. I placed the FIR.
I'll read the FIR, but first let me understand whether you admittedly were an employee of the company or not.
At that time, we were probably
All right.
employee.
Now come to A.
Wrongfully obtains possession of any property of a company.
So the house was not allotted to you.
Neither allotted nor our possession nor it is the allegation.
This is your, neither allotted is one thing.
No.
You were in possession, that was their allegation.
No, that is also not the allegation.
All right.
That is not the prosecution case also.
All right.
Property of company or having such property in its possession wrongfully withholds it or knowingly applies it to the purposes other than the expressed or directed in the article or authorized by this act. None of the allegation is against me.
Yes.
The beginning of the allegation, your Lordship, can see an extra one.
Please.
Subsequently, he shall on the complaint of the company or any creditor or contributory thereof, none of them are the complainant, be punishable with fine which may extend to 10,000 rupees. The complaint protest petition itself will make it clear that it is not filed by either of these three.
Yes. So where is the complaint issue?
Yeah, the FIR will logically see how it began. Page 19, annexure 1.
Annexure 1 to your petition.
My lord, revision petition. Page 19.
Yes.
I am to inform you that the MCL management has constructed 8 seat-type quarters by the side of the central hospital, which were meant for accommodation of senior doctors. These quarters are completed except water supply and electrical services connection, which is also under progress. These quarters were allotted to the eligible doctors of the eligible doctor. Most of the doctors have partially shifted their luggage and were under the process as of final shifting. The copies of the allotment letters are enclosed. Today, that is on 1/8/94 morning, Dr. J. Saha and Saiban Mukhopadhyay reported that last night some unknown persons have broken the locks of quarter number 384 and entered into those quarters allotted to them. The unknown persons have also put other lockers on the respective front doors. They further reported that 2 banners, 1 board and 1 statue have also been put by somebody in one of the blocks. The content of the board and banners are not as follows. No allegation against me.
Then
thereafter, I have stated in my petition the matter inquired by the police. You'll logically see the page 5, paragraph 5, that after due investigation on the report made by the opposite party, the investigating officer of the said case submitted final form by stating that plot number such and such area 4.6 decimal is a forest land. The MCL attached the said land without taking proper authority had constructed two blocks of C-type quarters over the land in spite of repeated objections by Gajanan Sahu and others. It is further stated in the final form that on verification of RA record and examination of neighboring witnesses, it was found that the land was in possession of Gajanan Sahu and others. My name is also not whispered in that investigation.
So what is your name?
My name, the petitioner,
What is your name?
Anit Kumar Chakravarti. Petitioner is Anit Kumar, accused petitioner is Anit Kumar Chakravarti. It is further stated in the final form that on verification of RA record and examination of neighboring witnesses, it was found that the land was in possession of Gajanan Sahu and others. Earlier than the MCL attesting, since both the parties failed to produce the record of right of the land, that is dispute, and he submitted PR under section 145 CRPC against both parties. That on receiving the final form, the learned SDGM issued notice to the complainant and opposite party intimating about the submission of the final form. On receiving the said notice, the opposite party filed the protest petition, which is registered as 160 case number 54 of 94 in his capacity as described in the cause title, as he then was the East Valley area against the present petitioner by mentioning that the relevant section is 448, 457 IPC under section 360 of the Companies Act. By describing the time and place of the occurrence as night such and such, such and such. The said quarters were constructed for the doctors of the hospital, such and such. This is the averment in the protest petition. Then you will logically see the next paragraph, paragraph 6. There is further stated that after the FIR was lodged, the police called upon the opposite party to produce the relevant document in respect of the land for demarcation and further legal action. And in that same notice, it has been written that present petitioner has produced some relevant documents. So while investigating the case, I was called to produce some document, I produced. And in that basis, the petitioner is an employee of the MCL and is the joint secretary of the Bajranagar Coal Mines Workers Union. The opposite party is one of the principal officers of IB East Valley area of the MCL. The quarters which were allotted to Dr. Shah such and such were on block.
So that aspect has been dealt with.
Mala?
Merely because the name of the company was omitted in the complaint petition, it could not be treated to be a private complaint. That aspect has been dealt with by the trial court.
No, not with all respect. But your lordship can see the evidence. The PW1 has even not stated so. The evidence your lordship can see Annex 3 of the evidence of the PW1 when he was alive. Otherwise, the company would have come and appeared before the court. If it would have been filed by the company in a perpetual body, there was no reason for which they are remaining long absent after his death. The company is a perpetual body. They should have continued, they should have appeared. 1CC number 54, deposition of witness number 1 for the complaint, aged about 45 years, Salo such and such. My name is Arun Krishna Hazare. I am son of Krishna Rao Hazare. My age is 46 years. My name is such and such, Chandrasekhar Station, District Chandrapur.
But his evidence was not recorded.
Recorded. This is the evidence of PW1 report here deposed.
Yes.
This evidence of the complainant opposite party number 1, opposite party. I have been working in the present capacity from the year 1990. I know the accused Amit Kumar Chakravarti in this case. The accused is working under the mineral manager of Mahanadi Coalfield Limited, Oriel Colliery. The Mahanadi Coalfield had constructed 8 quarters at hostel complex such and such, East Valley area for occupation of senior doctors of Central Hospital. I was in charge of the construction of the said quarters. Those quarters were constructed by contractor Nirmal Kumar Athwan. This is office copy of the work order to the said contractor. In the month of October 1993 for construction of these quarters marked as Exhibit 1. The construction of those quarters was completed in the month of March 1994. The personal administration of Department of Mahanadi Coalfield Limited allotted those quarters to some doctors, Oriental Hospital for occupation of said quarters in the month of April 1994. Some doctors occupied some of the quarters. Some were in the process of shifting the same quarters. On 1st August 1994, I received the copy of the letter of Deputy Chief Medical Officer of Oriental Hospital, Ib Valley area, addressed to General Manager, Ib Valley area, MCL, that quarter number 3 and 4 allotted to Dr. Shah and Dr. S. Mukhopadhyay, respectively, were forcibly occupied by some members of the Workers' Union AITUC. This is a copy of the letter which I received with mark. On receiving that letter, I made discussion with the General Manager and thereafter lost the affair. So it's not by the company. As required, because company means there has to be a resolution has to be passed and company must authorize someone to file a complaint on behalf of the company before OIC Orient PS for illegal occupation of the said date. This is the copy of the FIR marked as Exhibit 3. Thereafter, on 9/8/94, I found a construction of a pedestal in front of the quarter 40C1. It is a Miller state property, forest land. The these trade union people probably, they were having their offices and occupying that thing. For which then proceeding was also going on 145, 107, etc. These people also wanted to take it forcibly without having any authority over the land. In this process, the dispute started. That is why the police referred the matter to 140 CRPC to take appropriate action in the revenue and civil jurisdiction. So, a report was again given to police for said unauthorized construction in my essence by S.K. Iman, Superintendent Engineer, Civil. This is copy of said report to police marked Exhibit 4. Police investigated the matter. During investigation, the police issued a letter to me asking me to produce some documents regarding the said land, as the accused claimed ownership of the said land. This is said letter received from OIC Orient PS marked as Exhibit 5. The information as called for by police was given to 23rd August 1994. This is the copy of the letter as per which the required information was submitted, marked as Exhibit 6. After investigation, informed me about the completion of the construction by him. The personal manager administration has allotted those quarters. I had received the copy of the letters in which the quarters allotted to the doctors. The electrification and sanitary fittings has been connected by the MCL authority. I do not know if the electric and water supply has been taken to the said quarters or not at present. From police, I came to know that the Anil Chakrabarti occupied the said quarters. Later, I saw Anil Chakrabarti in this campus of the said quarters. As I come to know from the police that Anil Chakrabarti is main claimant of the quarters and I do not know the name of others, I have filed this case against Anil Chakrabarti. So this is the presumption he said on the basis of which he has filed the case against.
All right.
It is the fact that on 1/8/94, this signboard AITCI was displaced in the quarter. Other 2 or 3 banners were also displaced to the said quarters. It is a fact that the statue of the Surendra Sai was constructed in front of the quarters number C1 in the night of 8/8/94. I cannot say who constructed the statue. The doctors in the respect of whom the quarters were allotted had informed the Deputy Chief Medical Officer, Central Hospital regarding unauthorized occupation of the said quarters by accused. Those letters were sent to General Manager by Deputy Chief Medical Officer, Central Hospital. I can produce those letters in court. It is not a fact that the accused was in occupation of the quarters since long. That is from the year 1989. It is not a fact that we do not produce.
So you are arguing this matter as if you are arguing an appeal.
Well, I am only placing the evidence. Your Lordship said it's not the appeal. I would have produced, in that case, I would have first submitted the judgments. Generally appeal as per the old practice, but now the practice is different.
No, practice has not changed. Law has not changed. Procedure
law has not changed, but the procedure adopted by different benches changes, man.
This is the procedure. When the scope of scope of an appeal is different from the scope of a revision. So you could have
that is what I said. On the basis of it here, I formed a question to be decided. Here on the face of it, the complaint itself is not by a company or creditor.
Right, that is a question of law which I decide.
My lord. Your Lordship can see here I have also formulated it. There are certain questions. Your Lordship can see page 3, paragraph 2. Whether the courts below were justified in law holding the petitioner guilty of the said offence without recording a finding that the petitioner wrongfully obtains the possession of the property of the company. Whether the impugned orders are sustainable in absence of clear evidence, not only the allegations to the effect, but also to prove in accordance with law that the property in the question belongs to the company. So that is also not there. whether the finding arrived at by the courts below that the complaint lost by the opposite party as he then was not being on behalf of the company or the creditor or the contributory of the company can maintain the prosecution on behalf of the company, whether the impugned orders are suspended. So this is the questions are to be decided here because.
All right, I'll decide. I will decide the question.
Next Friday, 15th.
Huh?
Your Lordship, posted to 15th for further hearing.
Why 15?
Monday?
Why? What is left? You have argued everything.
If your Lordship.
Do you have any further point to argue?
There are many.
There
are many things because the opposite party is not there. I have to argue for both.
Opposite party. You are not required to argue for the opposite party. We will not compel you to do
the point is that, my lord, in CRPC, the your Lordship knows, in absence of in the death of the accused, it can be continued. But there is no provision in case of the death of the complainant whether the proceeding will continue or not. Here in my
you are counsel of some standing at the bar. How can you make this submission?
No.
We are at the stage of criminal revision.
Yes, sir.
Yes, you have already been convicted by 2 courts.
But
you want this application to be disposed of because the complainant is dead.
No, but the whole point is that that is the law. I must take it to
That is not the law.
No, that is I must.
That cannot be.
No.
That can never be the law.
No, my lord, law means is not decided in that way. But there is no provision as to what will happen in case
that we will see. That the court will see.
Here in this case,
the complainant is dead, is immaterial. The only submission which you are making is that the complainant was an individual. The complaint was filed in his
not in that.
That can be decided even in his absence.
Yes. Then since your lordship said that the judgment has been dealt with, I will show to your lordship the judgment has not dealt anything regarding the requirement ingredients of the section 630.
All right.
So let us.
As you wish. As you wish. We are at your disposal.
No.
So if you want me to hear for 5-6 days, I am there. Otherwise, if there is some material, it's all right. So when do you want?
As your lordship, please. After that sentence, I have nothing further to have. It would have taken another 1 hour or 2 hours. If your lordship will extend to 5-6 days, then blame me for that. I can't help.
This matter on 15th.
No, let it be your lordship again.
I'll see.
15th.
Yes.
What I submitted, since the opposite is not there, your lordship said that they must have been dealt with. I have gone through the judgment.
There is no question of must have been dealt with. It is your submission.
My lord.
It is your submission that he cannot represent the company. The complaint was filed in his individual capacity.
That is what I will show. So it has not been dealt with. The judgment, that is what I said from the beginning in the last week. The judgments are thoroughly perverse. They have not, with all respect, the line of magistrate has not gone through the provision of 630. What is the question of dealing with that? I will show the judgment. What your lordship says is okay, it is expected to deal with it. Here the point is that everybody is going with that quarter only. They have ignored the requirement of 630. They ignore the right of the Maharaj Coalfield Limited over the area. There is absolutely no material that the land belongs to them. If land doesn't belong to them, if they are in possession, they must prove their possession. That is also not there. And in the criminal case, they cannot do that thing. They have to approach the civil court if at all they were in possession of the land and they have constructed. So it is a government land, it is a forest land. Both the people are claiming possession over that land. So the whole point is that the dispute is that is why the police submitted to a proceeding under section 145. And that we do not know because the MCL has not come forward.
All right.
So say in that, since your lordship said that must have dealt with, that is what I say, that in absence of the
this question was framed by the trial court.
Yes.
That has been considered.
No, that is what because that is on the process of saying so, that is what I said that because the opposite party is dead, I have to say also on behalf of the.
You don't have to say. Why are you saying this? Why are you saying this repeatedly?
No.
Why should you argue his case?
No. Arguing in sense, my lord. Suppose I will say he has not dealt with. Who will reply? The opposite party will reply that it is there. Suppose you will say that it has not been dealt with. The trial court or the appellate court, even though we have taken the ground in appeal, if there is no ground in the appeal, I have stated in the petition that has been dealt with by the appellate court. So the whole point is that the entire judgment in a prejudicial manner, they say that because the land is a dispute, so they might have constructed, so convict him. Even though I was not there in the affair, not there in any manner, they have pleaded me as accused in the complaint. That is why I said, because I examine in case of death of the complainant, what will happen? In some cases, if they will come, they can be allowed to sue. But here in this case,
Please don't worry about the absence of the complainant. The court is there for even the deceased person. And the court will take care of that.
Manner, with all respect.
His presence,
I understand.
presence or absence is immaterial at this stage of revision.
I understand, madam. All right. Suppose, Miller, hypothetically, lordship allows by revision petition. Against whom I will, if you go, we will go hearing if the matter is, instead of dropping the proceeding, against whom I can file the suit for damages of
It's difficult. It's very difficult for me to answer to every question which you put to the court.
No, I ask only one question.
Yes.
Is the only
You could not have done this. And please don't do it in future. Don't put questions to the court.
So that in view, I say, I'm giving the reason
for which, Mr. Counsel, this is against the manners. Don't put questions to the court.
The answering while because
Please,